Okay, we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Good morning, everyone, and welcome to the beginning of this year's court term. Let me begin by introducing the panel to you. I'm joined by Justice Mary Sullivan and Justice John Englander. And as you can see from the square, my name is Ariane Vuono. Before I say anything else, I would like to thank our staff for all the work that they've done to be able to have us have these hearings remotely. They've really done an awful lot of work and we appreciate it. And we also appreciate your participating virtually as well. We may experience some technological difficulties during the course of today's argument. We hope not, but if we do, we ask you to be patient with us, and I can assure you, we will be patient with you as well. Before we begin with arguments today, I'll remind you that the same rules of appellate procedure apply here as they would if we were in the actual courtroom. So each side has 15 minutes. There is no rebuttal. You can be assured that we've read your briefs and everything else you've supplied us with respect to the record carefully, and you can get right to your main points. With that said, the first case I'm going to on our list for today is Commonwealth versus Nathaniel Simmons Jr. Attorney Shukecki, am I saying your name correctly? You're on mute.
I think I got it.
Okay, there you go. That's fine. So two things. Did I pronounce your client's name correctly? Is it Simmons or Simons?
It's Simmons, and my name is Suchecki.
Suchecki. Okay, please go ahead.
All right. Good morning, Your Honors. My name is Attorney Carl Suchecki. I represent Nathaniel Simmons. We would like to find this court to find that the hearing judge abused her discretion when she failed to terminate Mr. Simmons' probation due to judicial estoppel. In this, as the court found in the case of Convi Pacheco, or Pacheco, I'm not sure how it's pronounced, that when you're looking at a probation violation after a civil commitment, you look for the intent of the sentencing judge. And in this particular instance, it couldn't be more clear that the judge wanted the Mr. Simmons's probation to occur after his incarceration. He uses the word incarceration, and in his sentencing, there are 4 instances where he uses the terms from and after. So it's very clear in what the intent of the sentencing judge was. And when that's the case in a probation violation, in a civil commitment interrupting it, that means that the probation starts to run immediately after his period of incarceration. And that would mean, in Mr. Simmons' case, he actually went to probation after he was found found not sexually dangerous. He went and did some time doing probation, then he was violated, and he brought this motion to dismiss for it. And it's our contention that based on recent case law, Pacheco, that she should not have found the way she found.
Well, your client certainly didn't think that his probation began until after he was released from a sexually dangerous person's commitment, right?
Right, and Justice Englander, I'd go back to the language you used in Pacheco, and that just because whatever representation he made at the hearing doesn't affect what the sentencing judge did. There are only 2 ways to change a sentence. One would be the legislature, and one would be the sentencing judge himself or herself.
Well, let me ask a couple of questions, factual questions, counsel. As you know, I'm pretty familiar with the law here. The current status of your client, as I understand it, is that he was convicted of those subsequent serious offenses and sentenced to almost 30 years. Is that right?
Yeah, I represent him in that case as well, Your Honor.
Okay, so he, what he was eventually violated for, he was tried on. This is the part I wasn't clear on until I read a transcript yet last night. He was tried on, convicted after a jury trial, and sentenced to 30 years.
Correct.
roughly. Okay,
But that has no effect on what the,
I understand. Second, where is the evidence in the record as to what was actually said by your client or your client's representatives at the sexually dangerous person hearing about his understanding of his probation? Was, as I understand it, there's no transcript from the SDP hearing, right?
right. So I have no knowledge of what his representations were, except for the fact that he used his representatives used the fact that he was going to be on probation to get out of his civil commitment.
Where's the evidence of that? What do we know? What do we know about what was said, given that there is no transcript?
I'm going by representation of previous counsel, Your Honor.
I'm just trying to find it in the record. So the Commonwealth filed an opposition to the motion in which there was some sort of affidavit or supporting evidence.
I do not have it handy. If you'd like a 16L letter, I can further research it for you and get it for you, but I do not know the
Commonwealth can
I don't have
probably
the
answer
answer to your question.
question. I was just trying to
No, I
short circuit.
understand, Your Honor. I just don't have it.
Well, the motion judge does mention it, is that right, in her memorandum decision? And do
Yes,
you have an idea of where that came from, what she was relying on, oral representations, or as Justice Simmonds was asking, an affidavit?
I don't think that's in her memorandum as either, Your Honor.
Do you contest? I take it you don't contest that that representations were made that when your client was released from his SDP, he would be on probation for 3 years.
I think it was his impression and also his representative's
Not his
impression.
impression. What was said at the SDP hearing to the jury?
I have no idea what was said at the SDP hearing. I just had, like I said,
But you don't contest the Commonwealth's representation and the judge's conclusion that what was said at the SDP hearing was to the effect of he will be on probation for 3 more years, and that is why you should consider him not as sexually dangerous as he might be.
I'm not sure if it was said in that way. So a bit, but it's I think they
Wouldn't it matter?
I'm sorry.
Doesn't it, one of the things we struggled with in Pacheco is whether there should be a consequence to standing up and making a representation like that to a jury. And one of the problems we had in Pacheco, and frankly, I have it here as well, is there wasn't much of a record of what was said. Now in Pacheco, the judge rejected the argument of judicial estoppel, but here it was accepted.
Right.
So I'm just trying to explore what's in the record.
Without a transcript, I have no idea, except for what's represented by counsel. I don't know whether going forward in such cases, or maybe, I think that would be like a legislative, you'd have a legislature write it into the statute, or the sentencing judge be sensitive to the fact of what the consequences are when you say on or after, or like in Sheridan, there was after sentences. So that was clear that the probation would occur. I understand that the conundrum of the representation, the whole judicial estoppel balance, but as you said in the case Pacheco, you can't have anybody but the sentencing judge change it, short of the legislature.
You keep citing me to me. I don't know how that works.
I have to. It's there.
Of course.
Go ahead.
Go ahead, Justice Vuono.
No, I was just going to say, I draw your attention again to Judge Kelly Brown's memorandum and order, in which she does specifically say that what your client represented during the sexually dangerous person proceedings. So that must have been based on something.
Correct, Your Honor. And I do think it mirrors Pacheco in that way. It is that he made the representation, but everyone was under that impression. But the law is, and the only person who can change what the sentencing judge said was the sentencing judge. And the judge could not have been more, the plain language of what the judge said was on and after. And on and after means right after his incarceration, the probation starts to run. So by the time he was violated, the probation had already been over. And that's clear in the case law with Pacheco, and it's along the same lines as Sheridan in that way. It's the wording of the sentencing judge, and the sentencing judge specific about it.
I'd like to talk with you about what the consequences are, though, of of that position. Would you agree then that after Pacheco, in this case, if you prevail, that an individual seeking release in an SDP proceeding will no longer be able to argue that they will be on probation when the language is similar to this case and Pacheco?
I don't know whether without any kind of legislation or some type of, I think it has to come from the sentencing judge or legislation in order to change what's going forward in this instance. Because
But I'm asking you a different question. I'm saying, doesn't that then mean that person seeking release in an SDP proceeding will not be able to make the argument anymore that they're going to be on probation in the community because their probation will have already run, depending on how the numbers work. But in a situation like this, that's not going to be an argument available to clients such as yours anymore.
Yeah, if it mirrors a case like this or Pacheco, yes, they couldn't argue that.
Okay. And then the other piece of it is in Ruiz, the Supreme Judicial Court was concerned that criminal defendants were unaware that their probation was running while they were incarcerated. And if we look at Ruiz, was this sentence sufficiently clear to put your client on notice that he was on probation while he was incarcerated?
I don't know the particular client. I don't think necessarily that my client's sophisticated enough to know the nuances of when probations run, and this is a particular legal nuance here. Our case is a little different.
Well, but that's not what our case law says. Ruiz says the defendant has to know, has to be at least on fair notice. And they looked in part to the probation conditions sheet that he signed. Was that in the record before Judge Kelly, and do we have it?
I do not have it, nor have I seen it.
I saw a reference to the fact that there were conditions in one of the hearing transcripts, but I've not been able to locate the conditions there. In Pacheco, the conditions were right in the court docket. In this case, the conditions were not in the court docket, so I don't know where those are either.
Do we know?
I'm sorry.
Do we know if Judge Kelly had them before her?
I do not know if she had them before, Your Honor. I was not the hearing counsel, but I do want to point out one difference also in our case is that at that time when the judge made his sentence, there was no civil commitment statute, so he could not have contemplated that as a possibility as well. So based on the clear language of what the sentencing judge said, it's unequivocal that Mr. Simmons's probation would run right after his incarceration, and that it had lapsed.
We do have the Supreme Judicial Court's case in Morass, in which describing other civil commitment, mental health commitment, the SJC said that being held in this fashion is, quote, the functional equivalent of incarceration. Does that impact the analysis at all?
No, because I would go to the language in Pacheco, which says that quite the contrary. And Pacheco, in a footnote, that the quote is, the defendant's civil commitment pursuant to General Laws 123A serves different purposes, is distinct from any criminal penalty, and does not constitute incarceration. And that's
Citing Hill.
Hill, yeah.
Right, but how do we reconcile that with Morass, which says it is the functional equivalent of incarceration? Perhaps not incarceration, as Hill pointed out, for double jeopardy purposes, but essentially the functional equivalent for purposes of knowing what the judge intended.
I think the functional equivalent doesn't mean that it's binding. I think that the fact that, I think that if you take a step back, if somebody's being committed for a particular time against their own desire to be there, you could term it incarceration. But in terms of the verbal, the words that we need to function under our law, it's not incarcerated, and we have to follow precedent, and we have to follow intent. And the intent in this case is the intent of the sentencing judge, and the sentencing judge's intent binds this court. And that intent was for the time to run right after his incarceration.
What I find tricky about this is if this case were decided after Pacheco, I would understand you completely. But if we're looking at intent as of the time it was written, based on the existing case law, including Ruiz, which says where a defendant is sentenced to both incarceration and probation, probation typically begins on the defendant's release from incarceration. And JUSPA, it's a strain to imagine the defendant was intended to be on probation while he was imprisoned. The case law suggested, at least, that the judge had to specifically say, I want this to run while this person's incarcerated. Does that create any kind of problem for your argument here, that it's very clear what the judge intended?
I don't think, not for my particular case. I think that if you're going backwards to a lot of these cases, if they come up, the words of the sentencing judge really bind. And if you're saying sentences as they did in Sheridan, then the probation does not run. But if you're saying after incarceration, I think the word incarceration is and directly means incarcerated in prison, not a civil commitment. And as the footnote says, it's not the same. So if there's no other further questions, I'll just rest on my brief, Your Honor.
I'll check to see if there's any further questions. Justice Sullivan, Justice Englander, I see none. All right, thank you very much for your argument. We'll turn now to Attorney Riley.
Good morning. Patricia Riley for Plymouth County District Attorney's Office. The Commonwealth in our brief basically conceded that the Pacheco decision kind of mirrored the facts of this particular case, in where the defendant had been tried very nervous. The defendant had been pled guilty back in 1999 during a period where there were no commitments, SDP commitments. The wording of the judge in the sentence was identical to the wording used in Pacheco, which was from and after release from incarceration. So we do believe that the Pacheco decision was the controlling decision. And I honestly couldn't think of a way to distinguish it. And of course, the court is free to decide that our case is different to warrant that the sentence imposed at the probation violation should be upheld. But unfortunately, the judicial estoppel argument that was used, that Judge Kelly Brown had based it on.
Let me ask you a question, if I may. If I just take a second. I'm curious about something, a bigger picture issue, if you will. I don't know if you can help me with this or not, but what do you see is happening now? In other words, now, of course, there are civil commitments. Now, of course, people who are charged with a sexual offense do face a petition by the Commonwealth. They may also admit themselves, but let's just say the typical situation is that there's a petition filed before the period of incarceration ends. Today, are judges aware it seemed to me that, let me back up. It seemed to me that Judge Kelly Brown already before the case, and I'm going to say Pacheco, not Pacheco, because I don't think there's an I in there. So we'll just see if we can do that instead. Was aware of the fact that this is an issue in sentencing, and one has to be more careful how they actually delineate what a sentence is. Now, of course, today judges are aware of these commitment issues. Has the language changed in your experience? Are people being more careful about that, or are they saying from and after a period of civil commitment, or not?
I think that the sentencing judge has to be very careful to make sure that the intent is very clear, that it's release into the community, because I can see down the line where someone challenging release into the community, they want to be more specific. What community? Is it the community of a hospital, or is it the community, upon release from a commitment, a civil commitment? So
Correct.
the judge's intentions when sentencing has to be very clear on the record that, and I think the fact that a judge has imposed conditions of release, probation conditions, that are only really relevant to release into the community should be a factor the court should weigh. However, in the
Were
Pacheco,
there conditions in this case?
I beg your pardon, Your Honor?
Were there conditions in this case?
As Your Honor had said, there, I could find no conditions in the actual court docket. So I'm unaware of any conditions in this particular case.
But there's a reference to them, and if I went back into the hearing transcript that I read yesterday, I'd find it. There's a reference to conditions that are very similar. They sound very similar to the conditions in Pacheco, one of which is no contact with the victim, which it seems to me, as we say in Pacheco, is something that could certainly apply while somebody is in a civil commitment.
Absolutely. There are some conditions that were in Pacheco that were relevant while he was committed, or whether he would be out in the community. Drug and alcohol free with screens, for example. They can do that while a person is civilly committed, and they can do that.
No contact with minors. If somebody's on a civil commitment and yet they, for some reason, have the ability to leave the premises for a certain period of time, which happens, no contact with minors would also be relevant during that period. That's why I'm asking whether there were any conditions, but we don't know.
I don't know, Your Honor. As you said, usually it's right in the court dockets, and I could not find that where there were specific conditions.
Are you able to tell me anything more about what the record showed with respect to your claim of judicial estoppel before Judge Kelly Brown? How was it proved?
Unfortunately, the only reference I could find to the judicial estoppel arguments were within Judge Kelly Brown's decision. And unfortunately, I could not actually find a transcript. And it looks like some of the information from the SDP hearings, because of privacy reasons, are not available. So I was not able to.
I know there's no transcript there, but she had an affidavit from counsel, at least in front of her. She references it when she's in the first hearing, and in I believe it's May of that year. Someone references an affidavit from a district attorney as to what was said.
And again, I don't have that. I do know that she did factor it in, but again, that too was factored in Pacheco. That judicial estoppel did not apply because the court had found in Pacheco that you can't tack on. You can't
use a representation in court to change the length of the sentence. And any way you look at this, that's what Pacheco says. Any way you look at this, that is what is happening. In order to understand when probation ends, you would have to accept the representation made by the defendant. And so that's the holding in Pacheco. I take it the Commonwealth doesn't challenge that here.
That's not, if that's the holding in Pacheco, and that's the court's holding, but that's not my read from the Pacheco decision. When I read the Pacheco decision, my interpretation was that the defendant did argue at his SDP hearing or his trial that he was going to be on probation when he was released from his commitment. And that's the exact same situation. Well, even without being able to support that with the transcript, arguing that it was the same representation, then why wouldn't it apply here as well? I'm not saying that.
I agree.
agree, but it's,
I
I
think we're
just don't
talking
understand
across
the
purposes now.
I'm sorry?
I said, I think we're talking across purposes. I don't find a way to see a difference between the two cases from the perspective of how judicial estoppel was argued or applied.
And I agree. I can't find the difference. And again, I would like to find the difference. I would like to be able to say that when someone does argue and relies on that position and a jury hears that position and he's successful in that position, that he shouldn't be allowed to come out and be able to use that, the flip side on to his benefit. And that's the case law with that, the insurance case, that Otis versus Marabella. He shouldn't be able to use the same argument, take the opposite position when he's been successful at the first position, on his first position, in reliance of that position.
So what needed to happen,
In part.
counsel, is the Commonwealth needed to say that argument in the SDP proceeding, Your Honor, you have to preclude that argument from being made because it is legally incorrect. It is not what his sentence is, and he is not subject to probation anymore. And that's what the Commonwealth is going to need to do in the future.
Well, since 2019, when this case was issued, the Commonwealth, I presume, was on notice to examine carefully what the terms of probation are in any given case. That's before a judge on a Section 9 hearing.
And I think,
Counsel, do you have any sense of how many cases there are like this out there where probation conditions were set before our 2019 case, and this kind of interpretation now for purposes of probation violation is required?
I don't, Your Honor. And it's troubling, but I think now one thing that can be argued is since 1999, I think it was November of 1999, civil commitment has been much more of a possibility. So I'm hoping that that sentences after the civil commit statute was imposed would address interrelease into the community, or some such wording so that the judge's intent was when the individual is back amongst society as a whole. And I think
This case was 1997, I believe. The initial sentence was
1989,
imposed.
Your Honor.
Oh, okay. Even further.
Pacheco was 1997.
Well, what about also Commonwealth versus Ruiz that Justice Sullivan had brought up earlier? In that case, that's 2009. And in that case, Chief Justice Marshall makes clear, look, a defendant needs to be on notice of what his conditions of probation are and when they start. So from 2009, at least, I mean, not that judges might not have known that beforehand, would know that they'd have to be clear in terms of when conditions of probation start. In that case, the problem was that they did not start while the person was incarcerated. They began upon release. So what do you think that case has perhaps been a safeguard to a certain extent to the problem that we have here?
Well, I'm slightly embarrassed to say I'm not familiar with the case. However, that being said, I don't know how that could impact the logic behind the Pacheco decision, and that it doesn't matter whether or not, according to.
No, I'm not saying that it does. I was asking whether or not that was another a case that came out that would have the consequence of informing judges that they have to be more careful with how they set terms of conditions of probation. That was, but that I won't ask you to comment on a case you're not familiar with. Thank you.
If there are no further questions, then I would rely on my brief as well.
All right, I'm going to check with the panel. Justice Sullivan, Justice Englander? No, I see no further questions. Thank you both very much for participating on this remote platform. We appreciate it. And on behalf of the panel, we hope that you and your families remain safe and healthy throughout this time period. Okay?
Thank you.
Thank you, Your Honors.
Bye now. All right, good morning. Attorney Combs and Attorney Cusack, can you hear us?
Yes.
Can hear you.
Yes. Okay, great. Welcome to the beginning of the court term. Let me start by introducing our panel to you. Joining me is Justice Mary Sullivan, Justice John Englander, and my name is Ariane Vuono. Next, I'd like to thank our court staff for making this possible to have these remote hearings, and we'd like to thank the both of you for participating virtually as well. We may experience some technological difficulties during the course of the argument. I hope not. So far, we're running smoothly. But if we do, we expect you to be patient with us, and we will return the favor and be patient with the both of you if you should have any difficulties as well. I'm going to remind you that the same rules of appellate procedure that apply as if you were in the courtroom apply here. Each of you have 15 minutes to make your argument. There is no rebuttal. You can be assured that we have read your briefs and the record well, and so it might behoove you to get right to your best argument as soon as possible. Okay, I'm going to call the case officially now. Commonwealth versus LUZ FIGUEROA, 2019-1592. Attorney Combs.
Good morning, everybody. May it please the court, Thomas Combs for LUZ FIGUEROA. Your Honors, at every juncture in this case, Ms. Figueroa experienced a real concerning, essentially a failure of one kind or another of our criminal justice system. First, as Your Honor has seen in my brief, she was made to endure an oppressive, coercive interrogation at the hands of Officer Kuhn that left her in tears at the end of it. Then she had the misfortune to hire an attorney, Mr. Friedman, who, because of his manifest incompetence, could not adequately litigate a motion to suppress that really presented some viable issues for her. And then she's ultimately convicted on a case which, in my view, had insufficient evidence and which was made up in large part of inadmissible accusatory statements, which she denied. What I'd like to do is take the sufficiency issue first, if that's okay with the court. The essential thrust of what I see here is there was a lot of evidence that can more or less be categorized as consciousness of guilt. There's a lot of different versions. I think myself and the Commonwealth both, identify many of these areas. A lot of them come from the text message conversation that was admitted as a large exhibit. Another large portion comes from the interrogation, which even in a redacted form was a little over an hour long. What troubles me is the lack of real evidence that would connect Ms. Figueroa to this crime. There's so many inferential leaps that are required to get her from being kind of present in her apartment at the time that a theft was committed in another part of the apartment building.
Excuse me, wasn't she on the telephone with the victim at the time that the crime occurred, or close to the time?
Sorry, yes, that's a very good example, because in that case, it's really crucial to note that the complainant, Mr. Molino, called her. So if we are to be drawing inferences about her behavior at that time, it's one thing if she's calling, seeking information, wanting to know, where are you? Are you out of the apartment? It's entirely another thing for the complainant to call her so that she's just receiving a call. So does she have awareness? She might, but is it a fair inference that she is seeking information so that she can somehow coordinate with the principal to have the theft committed? This is part of the issue that I see with this case. I don't believe that inference is necessarily warranted, because you have to draw.
Well, I think that you're inferring a lot more than the jury had to from that piece of information. I was simply suggesting that a reasonable inference would be is that she was present at the apartment building, that there was evidence that she was there at the time.
Oh yes, I certainly can see that. I don't think there's any question that she was there. But again, as I dug deeper into the cases that,
She was in her apartment. There's no evidence she was in his.
right,
Right?
the Commonwealth's theory
Right.
was never that she was present in the complainant's apartment during the time of the theft. Their theory at all times was that she was in her own apartment,
Right.
but she was somehow part of a joint venture with the principal.
So she says,
Oh.
sorry, go ahead.
So how do you deal with her statement in text message to the victim, to whom she had initially denied involvement, but then admitted that she told her uncle, and she says, I admit to it, and now I'm going to do time. Could not the jury infer from that statement that she had been involved?
What she's admitting to there, to be very clear about the nature of that admission, what she's admitting to is having essentially let slip to her uncle that money existed in the apartment. I mean, that if the court reads that,
I understand that argument, and that is certainly an excellent argument for defense counsel to make, but could the jury not also have inferred from that statement something different, which is, I admit I did it?
again, I don't think that's a fair inference in the context of, I mean, if you look at the entirety of the text message conversation and the interrogation with Officer Kuhn, the entirety of that shows a consistent denial of involvement in the crime. And that specific text comes at a point when she's being accused of revealing to someone else that the complainant had money in the apartment. So the admission there is that, yes, I'm sorry, I revealed it to my uncle, but I didn't have anything to do with the theft itself. So I admitted I'm going to do time, again, is not a confession in the context of the evidence because of her adamant denials at all other times.
Well, again, that's her theory of the case. And I would agree with Judge Sullivan. It was a good theory and put to the jury, but the jury didn't have to accept it. And of course, now we're looking at those text messages in the light most favorable to the Commonwealth in order to determine whether or not the evidence was sufficient of a joint venture, right?
It's true. And what that makes me think of is this recent case, Commonwealth versus Lopez, decided by the SJC, which talks about the effect of a theory on the evidence and how that relates to sufficiency. What Lopez essentially says is you can't kind of mutilate the evidence by saying, well, we accept this part of it. Let's say we accept that she was present. We accept that she said this thing, that she made mention to her uncle. So we accept that those are true, but then we accept that other portions are not true. I mean, to look at the whole of her conversations is to see that she consistently denied having anything to do with the actual theft.
She also consistently denied on the 5th, when she's in the interrogation, she consistently denied having told anybody about the money. And then a day later, she admits she told her uncle about the money. Now, where does that get the Commonwealth? That's incriminating, right?
It absolutely is incriminating. And I think it's fairly characterized as consciousness of guilt.
Well, it's a little bit more than consciousness of guilt, isn't it? It's evidence of an action that could have been in furtherance of aiding and abetting a larceny.
What I would ask the court then to turn to is the Gonzalez case and the Mandil case. Those are two cases that stand for similar propositions as here. They both address sufficiency of joint venture. They both find the evidence insufficient. And in both of those cases, there's really, really strong evidence of consciousness of guilt. I mean, in some cases, they're much stronger than we find in Ms. Figueroa's case. One, I think in Mandil, the co-defendant who was not the principal, in fact, took the murder weapon and disposed of it. So thereby trying to cover up this crime committed by the principal. In Gonzalez, it was a similar thing where the defendant in that case was supposedly a driver of a car that was present that had other people that were involved in the commission of the crime. She thereafter lied about her, or at least in the light most favorable of the Commonwealth, lied about where she was. The SJC in both of those cases characterized those efforts to misdirect as consciousness of guilt. And in both of those cases, they said consciousness of guilt is not enough to survive sufficiency. So presence motive, opportunity, plus consciousness of guilt is not enough. That's what those cases stand for. And I think that this case actually presents a case that's not nearly as strong as the evidence in those cases.
Those are your two best cases, right? Mandil and Gonzalez?
There's other ones as well. I mean, it's a very specific issue we're dealing with here, the joint venture as to, the principal. I would point the court to other cases. Maza is one that's from 1987, I believe. Swafford is another. They are cited in my brief and my reply. But what all those cases stand for essentially is this combination of consciousness of guilt, even motive and opportunity, presence. This is not enough when you have to make inferential leaps to get you to the actual intent required for the crime.
Well, we have a few instances of consciousness of guilt. We have the fictitious black men and then the fictitious two black men upon whom she tries to cast blame. We have the denials. But again, we have the text message, which is not a consciousness of guilt, which is not consciousness of guilt evidence. It's arguably an admission. So once you have the text message, I admit it, I'm going to do time, then we're not dealing with consciousness of guilt alone, are we?
Again, I believe that a fair reading of that piece of evidence is not an admission to the theft. She is admitting, and I would agree again that could be.
But even if it's debatable what that is, it's evidence which is other than consciousness of guilt evidence, is it not?
I would push back a little bit on that. I would characterize that as consciousness of guilt because, as you said, in the interrogation, it was stated that she didn't tell anyone else about it. And now she's, again, the nature of her admission in that text message is, I admit it, I told my uncle. But again, she's very, very clear. I had nothing to do with the theft. This is not the sort of gotcha moment where she's saying, I admit it. I stole the money. I'm guilty of that. She's saying, I admit it. I told my uncle, but I did not have anything to do with the theft. She's adamant about that. So I think that that's most fairly categorized as conscious of guilt. She's saying, yes, fine. I didn't say that before. The Commonwealth can then argue, now she's revealing that she did tell her uncle.
Well, it's true that a false statement is generally falls into the category of consciousness of guilt, but it's also true that a false statement can be more than that. It can also be circumstantial evidence of guilt. For example, other circumstantial evidence in this case that the jury could have relied upon was the offer of on behalf of your client's boyfriend to loan $5,000 to the victim on that very same night. I think the jury could have thought that was a significant piece of evidence as well. It does fall somewhat into it straddles the category of consciousness of guilt evidence and circumstantial evidence of the crime.
See, again, in my view, that's almost the classic version of consciousness of guilt. And again, there's also a distinction there because it's Ms. Figueroa's boyfriend who's making that offer, who, from the evidence that we had at trial, appears to have some kind of independent relationship with the complainant in the case. But that, to me, if the idea is that the offer of a loan is due to feelings of guilt about the theft, again, that's classic, in a sense, consciousness of guilt. Is consciousness of guilt relevant for trial? Absolutely. That's, the Tony case that the Commonwealth cites, that and other cases make it pretty clear that evidence is relevant, it's admissible. But there's a very different question that we have to answer when we talk about sufficiency. And again, these cases that go back many years that have been pretty consistent over time, whether it's Maza, Salem from 1985. These are echoed in Gonzalez, which I think was 2016, and was again kind of reiterated in, I think it's Lopez in 2020, just in March of this year. So these cases are very clear that consciousness of guilt evidence cannot kind of bootstrap an otherwise insufficient case.
You've answered most of our questions so far on sufficiency of the evidence, and your time is short. Was there any other issues you want to address before your time is over? Really briefly,
Obviously, my last argument concerns the admission of accusatory statements. That comes in two forms. It comes in the interrogation and it comes in the text messages. The one thing I want to leave with the court is, the Commonwealth has stated that that defense counsel used those to her advantage, that there was a strategic reason to allow them to come in. I don't necessarily disagree with that, but in the question, when the court is looking at what the prejudice of that is, you have to balance both the strength of the case versus whether or not there, versus the nature of the error, the context of the error, and then whether or not there is a strategic reason, not to object. In this case, essentially just to allow those to come in. So really, I mean, the thrust of that argument is this was not a particularly strong case with all the potential evidence that the government, or rather the police never looked into, all the links that are missing.
Counsel?
Yeah.
Can you hear me?
I can hear you.
I'm sorry, I had a little glitch there. Am I right that there were no objections to this at all before the judge? No objections to what was actually read in, and no objections to what went in on the video?
That's correct.
All right, so what's a judge supposed to do? I mean, he's supposed to figure out on his own that there's a substantial risk of a miscarriage of justice, and he needs to keep all this out under circumstances where there's an evident potentially conclusion that this is advantageous to your client, because she must have denied 100 times that she was involved in these two different documents. So what's a judge to do? Are we really to reverse this because the judge didn't figure it out on his own?
I mean, I suppose that could be said for any case where there's no objection, where there's I'm not suggesting that the level of review here is any higher.
Why I said that here there was an evident reason for them to allow this, which was to also put in, along with it, your client's repeated denials that she was involved.
No, I understand that. And again, as I said, when you look at substantial risk, you're looking at a balance. You're looking at is the erroneous admission of those statements. So, sorry, I'm running out of time here. So suffice to say, it's a balancing.
Okay.
Yeah.
I think you've answered the question. Let me just check with Justice Englander. Is that correct?
I'm fine.
You're also okay. And Justice Sullivan, any further questions on your behalf? Okay. Thank you very much. We're going to turn now. Thank you for your argument to Attorney Cusick. Thank you.
Thank you, Your Honors. May it please support Tracy Cusick for the Commonwealth. Your Honors, the Commonwealth asked this court to affirm this defendant's convictions for breaking and entering with the intent to commit a felony, larceny over $250, and vandalism, defacement of property. Here, the evidence was sufficient to establish that the defendant knowingly participated in all of these offenses with the requisite intent. Your Honor, starting with the accusatory statements, clearly there was a strategic reason for this. There was a motion for new trial. At no time in the motion for new trial did trial counsel—
Back up and talk about sufficiency, since that was the first issue. Do you mind?
Oh, certainly, Your Honor.
Okay. What is the evidence that this defendant participated in this offense?
This defendant was one of the few people who knew that the victim had thousands of dollars hidden in his apartment. This defendant knew specifically that it was in the bedroom. She admits at one point in the bedroom. When the money was stolen, it was stolen, one could infer, by someone who knew exactly where to look for it, because the apartment was otherwise undisturbed. Other valuable items were still present. Valuable tools had not been removed. This defendant places herself in the apartment building on the deck, scanning the parking lot. There's testimony about a telephone call between the defendant and the victim. I believe at one point the defendant may have said that she had contacted him, but regardless of who called who, there was evidence also that
every single fact you've identified so far, absolutely on its own, completely innocent.
I agree, Your Honor. I agree. Those
convict somebody of larceny because they know someone else has money in their house, right?
I agree with that. Yes.
Okay. So those are their first three facts. And then your second two facts were she had a conversation with him.
Yes, Your Honor.
What is the evidence that she participated in the larceny?
The evidence is that she told her uncle, who she knew had a history of theft from other people, about the location of the money in the apartment. She told the uncle. One could infer then from other evidence that she was there, knew the victim was away, scanning the parking lot, has the story about the suspicious other people that she claims came into the building. But then later, when asked by police, who else did you tell about this? And she repeatedly denies having told anybody else about this. Meanwhile, she and the boyfriend offer the victim a loan of $5,000. Again, there's other evidence from the defendant that she's broke or she doesn't have any money, but somehow they come up with $5,000 to loan him if he had wanted that money. And then she admits that it was in fact the uncle and claims that there's some efforts underway to get the money back.
So the evidence of participation, let's just focus on the active thing that she did, which she did admit to, which is she told her uncle about the location. And let's say that's the evidence of participation. Where is the evidence that she intended a larceny to occur? Surely telling him alone, is that enough for a jury to infer?
It's a factor a jury could consider. Alone, it may not be, but that's not alone what we have here. When the victim returns home, discovers the theft, calls the police, runs up to the defendant's apartment to tell her, she doesn't mention anything but she saw these suspicious characters in the parking lot. Then when the police bring the victim back to his apartment, she's still there. She's present, even though they'd asked her to leave. They wanted to speak only to the victim. And then she sort of collapses. So again, arguably consciousness of guilt evidence, but again, her behavior at the time is rather extraordinary. And then again, she does subsequently acknowledge she did tell the uncle, and the interpretation of the text message, I admit it, now I'm going to do time, is up to interpretation as to exactly what she meant in that. But a jury could have inferred she meant.
Can the jury really infer that she's admitting that she was involved in the larceny when she said 100 other times in the same conversation, I didn't do it, I wasn't involved? Is that a fair inference to draw?
I believe it is a fair inference to draw, Your Honor. Again, she repeatedly denied it and then admits, oh, I did tell someone.
She denied it before and she denied it afterwards. Your brother says the only reasonable way to read that is that she was admitting she told somebody, not that she was admitting she was involved in the larceny. What do you say to that?
If you add all the other evidence in, I suggest that reading is not a fair inference of it. That again, the repeated denials, then she admits to it, then she acknowledges that this uncle has a history of theft from other people, and again, that she told him it was in the bedroom, which I know counsel characterized it as a.
Is it in the stream that she acknowledges the uncle had a history of theft in the text stream?
In the text messages, she says he stole from other family members, a grandmother or something like that. There is a text message where she references that in one of those text messages, which is in evidence, which is in the record appendix in this case. So I would suggest the evidence was sufficient.
Take the position that she could have been tried as the person who, on this evidence, tried and convicted of actually committing the larceny?
The theory at trial was that somebody else went into the apartment and took the money. The Commonwealth's theory at trial was quite clear that that the Commonwealth was not suggesting she had been in the apartment to personally take the money.
But do you agree then, does the Commonwealth concede that there wasn't enough evidence to convict her of actually doing the larceny herself here?
Your Honor, I've never evaluated the case in that sense. With evidence at trial, I don't believe would have been enough to try her as a principal, but it may have been there was other evidence that didn't go in. Because the Commonwealth was very clear in its presentation that that was not the theory.
So if the evidence that went in here that we're talking about that actually went in is not sufficient to try her as being the person who actually went in, what makes it enough to be the aider and abettor?
The fact that she had communicated the location, specific location of the hidden money to another person. the Commonwealth suggests a fair reading of it is with the intent that that person will take the money.
What items of evidence do you consider to be not consciousness of guilt?
Her statement that she told the uncle about the money. Her statement, I admit it. That's not consciousness of guilt. Her being present at the apartment complex in the parking lot and her description of what she says she saw and being on the phone, not consciousness of guilt. And her offer of the loan to the victim, I suggest, indicates access to cash, which would be consistent with having stole the money. If I could address the motion to suppress issue.
Go ahead.
Your Honors, for the motion to suppress, the court, I believe, has the recording, the audio video recording of the motion to suppress. I don't know if the court has had an opportunity to review the unredacted video of the interview of the defendant, but I would encourage the court to do so, because certainly that review of the video shows that this was not an impressive interrogation. The defendant comes to the police station to provide elimination fingerprints and then is asked to participate in an interview. She is given Miranda warnings. Throughout the interview, I suggest that the tone is conversational. She repeatedly uses her telephone. She's calling people. People seem to be calling her. She is texting. There are at times 3 officers in the room, and they repeatedly urge her to allow them to examine her telephone. And she states that there's evidence there that someone might construe as she's selling drugs or something of that nature, and she doesn't want her kids to get taken away. And she doesn't let them have the telephone. She's never worn down. Her will is never overborne. She refuses to allow them access to the telephone. Nobody takes the telephone. Police were never able to examine that telephone. So certainly I'd suggest review of the entire audio video recording shows that. And to the extent the police reference her children in terms of wanting to search her home, she responds immediately, oh, well, if you arrest me, they have another parent. She calls her mother. She certainly negotiates the circumstances.
Breaks down and cries. She is repeatedly threatened with what's going to happen to the kids. That's not legit under our case law, is it, counsel?
Your Honor, no, threatening someone about children, no, that is not legitimate. But
it happens over and over again. Officer Kuhn, someone needs to have a conversation with, regardless of the outcome, right?
Certainly, Your Honor, I'd suggest it's not appropriate. I agree with the court. It's not appropriate to threaten somebody with the loss of their children. But I would encourage the court to actually watch the recording of it, because I suggest that this is more dealing with a logistical challenge of, hey, if you get arrested, what about your kids? We're going to have to call DCF. It certainly doesn't rise to the level of what happened in the cases cited in the defense brief.
The difficulty I have with your opponent's argument, and I noticed they didn't spend a lot of time on it, is even if there were improprieties in the questioning here, it's not clear what the consequence of that is. What statements they're trying to not have admitted into evidence, it seems to me, are not really the consequence of what was said. And I would have asked your brother this, but I mean, the statements that are most powerful for you are statements where she denies having told anybody and then turns around the next day and admits she did, which those statements were not, I think, the consequence of the questioning. I don't know that there's a question here, but it's an observation.
Let me put it a different way. First of all, does the doctrine regarding accusatory statements apply to text messages between private parties? And what's your best case to support your answer?
Your Honor, I would think it would apply to a conversation between private parties. Again, the victim is saying, you did it or confess or stuff like that. Certainly he's accusing her. I apologize, I don't have a case off the top of my head. I will look for one and provide one to the court. But I would suggest here that these were admitted as a strategic decision on the part of the defense counsel. Certainly there was a motion in limine to exclude. There was some text message that was excluded. I believe it addressed a topic that might be considered to allude to drugs, and that was excluded. There was a motion in limine filed by the defense attorney to exclude the certain statements, which is in the Commonwealth supplemental appendix. So there was a lot of thought put into what was coming in. This wasn't a surprise to anybody at the day of trial.
I only asked you the question about that because there was a sentence about it in the judge's ruling, but I didn't see any authority.
That was not state action.
Right. The other question would be whether or not an admission in response to an accusatory statement is admissible and is treated differently than accusatory statements with denials under the rule of hearsay. Are they treated differently?
I wouldn't think so, Your Honor. Again, because certainly
even the statement in the text message, I admit it, I'm going to do time. Is that admissible under our hearsay rules?
Yes, Your Honor, it is admissible. And I suggest again, where there's a disagreement about the import of that statement, that sort of shows why the whole chain of text messages is needed, so that the jury could decide what was the significance of that statement. Was she admitting she participated in the theft, or was she admitting to something else? I see my time is running out.
Well, we got 35 seconds. What do you say to the Gonzalez case? I mean, isn't your brother right that the evidence of participation and intent in Gonzalez is greater than it is in this case? And the judges, the Supreme Judicial Court said not enough.
If I'm remembering the case correctly, I apologize, Your Honor, if I'm not, but I believe it's the intent to commit murder. I believe.
Yep.
I apologize if I'm incorrect. That's a very different intent.
Why?
The specific intent for a first-degree murder is...
Doesn't there have to be specific intent to commit larceny?
The intent to commit the larceny here was the intent to take the property and permanently deprive the victim of it.
Okay,
So I suggest as
I don't
opposed...
understand. Is it a specific intent crime?
It is, yes, that is specific intent.
So
but
why are we talking about different doctrines if they're both specific intent crimes? I understand one is the intent to commit murder and the other is the intent to take property, but they're both specific intent crimes.
Your Honor, I would suggest that the doctrine for the intent for murder, I would suggest, is a different degree of intent. That if a murder had been committed in the apartment, I would suggest we would not have the intent that the defendant intended, what had a part of it.
I agree with you on that. On Gonzalez.
All right. If there are no further questions, your time is up, and I don't want to cut off the panel. Justice Sullivan? No? Justice Englander? No? All set. Okay. Thank you both very much.
Thank you, Your Honor.
Thank you again for participating in this forum. And on behalf of the panel, we hope that you and your families stay safe and healthy during this time period. By introducing the panel to you, we're joined today by Justice Mary Sullivan and Justice John Englander, and I am Ariane Vuono. Next, I'd like to thank our court staff for putting these platforms together so that we can continue to have these arguments during this challenging time. I also like to thank both of you for participating remotely. We may experience some technological difficulties. We haven't thus far, but if we do, we hope that you'll be patient with us, and we can assure you that we'll be patient with you as well should you run into any difficulties. I want to remind you that the same rules of appellate procedure regarding oral argument applies to these arguments. It's just as if you were in the courtroom. Each side has 15 minutes. There'll be a clock in the corner of your screen. There is no rebuttal. You can be assured that we've read everything that you have submitted to us. And so we look forward to hearing your argument, your best argument first. But with that, I'm going to call the case. Commonwealth versus DILSSON Hernandez, 2019-1384. And Attorney Cordagnone, you go first, right?
Thank you, Your Honor. May it please the court, Amy Cordagnone on behalf of DILSSON Hernandez. I'm asking that this court vacate Mr. Hernandez's conviction or alternatively grant him a new trial. And I'd like to start first with an argument about the state of the evidence, and specifically to ask that this court vacate Mr. Hernandez's conviction because the evidence showed that Mr. Hernandez was merely present in a location where drugs were secreted and is not sufficient to prove that he constructively possessed those drugs. The case law makes clear that the Commonwealth needs to show more than simply mere presence, as was the case here. The Commonwealth needs to supply some plus factor to indicate that Mr. Hernandez had the intention to exercise dominion and control over the drugs and that he had knowledge that the drugs were there. And here, the plus factors that are typically present are not here. There's no evidence that Mr. Hernandez made any furtive gestures, that he appeared nervous, that he had cash or drugs on his person. None of his personal items were found in the car or in the purse where the drugs were found secreted. There's no personal connection that's shown between him and the vehicle. Aside from the fact that he's seated in the driver's seat, there's no.
Well, what about the personal connection between him and the Mr. Paula?
The fact that he's present with Mr. Paula?
Well, no, the personal connection between the two. I mean, it was not a random meeting between the two. He picked him up and brought him over to that particular location.
Well, so Your Honor, in terms of what the Commonwealth's evidence was in their case in chief, I would ask that this court not consider Mr. Paula's testimony in determining whether or not the Commonwealth met their burden of proving the evidence.
We'll review the evidence that the Commonwealth presented in terms of determining whether or not the evidence is sufficient. We have to, that's the law. But
Sure.
There was evidence that the two of them had a connection beforehand by the Commonwealth, right? The two of them arrived together in the car at that place.
Sure. So, and that's the extent of it. The two of them arrived together in the same place, in the same car. Mr. Hernandez in the driver's seat, Mr. Paula in the passenger seat. And that's the evidence.
It's a little more than that, actually, isn't it, counsel? I mean, he didn't just happen to be sitting in the driver's seat. He drove Paula to that spot, right? We have that evidence. That comes from the Commonwealth.
Sure.
He chose to drive to a place that is a known area where drug transactions occur, right? In a car that had drugs on the floor, and then stopped his car and watched what a jury could infer is a drug transaction take place 2 cars away, right?
Yes, I think so. I think that there's 2 pieces to that I'd like to just address in terms of whether or not the drugs were on the floor in plain view of Mr. Hernandez. I would suggest that was not proven by the Commonwealth. I would suggest to the court that the evidence was that the purse was between Mr. Paula's feet, abutting the passenger seat, that the purse had tissue paper, that sort of thick tissue paper that's in a new product that was on top of the drugs.
Under circumstances, can't the jury infer that he knew there were drugs in the purse?
So I would suggest that the jury cannot infer knowledge where they were not in plain view.
Well,
the purse was in plain view.
I apologize. I didn't hear the question.
Go ahead, Judge Vuono.
I'm just saying the purse certainly was in plain view.
Sure. The purse, I would suggest that the purse was likely visible to a person who looked at the floor of the passenger seat. But the testimony was that it was abutting the seat in that it was sort of pressed up against it.
And it certainly wasn't naturally an item that Mr. Powell would have, because apparently it was a ladies' designer purse, correct?
Sure. Yes, it was a ladies' designer purse. But I think the important sort of other piece about this is we don't know anything about the owner of the vehicle. And so I don't know that there's anything that could be inferred in terms of whether it was Mr. Paula's, whether it was the owners of the vehicle.
Well, you're doing a good job of showing all the evidence the Commonwealth didn't have, which would have buttressed their case. There's no question about that. But if we look at the evidence that is there and the reasonable inferences that can be drawn therefrom, the jury could make something of the fact that in this car, there is a woman's purse on the floor and open, and that the person who's in the passenger seat next to it, arguably, reasonably, the jury can infer, has just engaged in a transaction of drug dealing, right? A drug transaction has taken place.
Sure. I think that that's possible, that those things could be inferred. It's possible that knowledge could be inferred, but still the Commonwealth bears the
Well,
burden
we
of
don't deal with
proving-
possibilities. Possibilities is not enough to find the unreasonable doubt. My question is, and the question we'll grapple with, is that a reasonable inference?
Is it a reasonable inference that the jury, that the jury thought that the drugs were in the purse, or that Mr. Hernandez has knowledge of that? Is that the question? I apologize.
Correct. I mean, you've indicated that because the drugs were not in plain view, my interpretation of your argument is that without being in plain view, that would basically vitiate the element of knowledge here. But knowledge could still be proved by the circumstantial evidence, right? And so that's what I was pointing out, is that there is evidence that he would know when he drove the car, had the car. Well, yes, we don't know who the driver of the car is. Is it a possibility that the prior owner left the drugs and left valuable drugs in an open purse in the car? I don't know how reasonable that would be, but that was an argument that was made to the jury, and it was rejected. So there is circumstantial evidence of your client's knowledge that there were drugs in the car.
So I think that this court may well draw that conclusion. I don't agree with that. I think that requires the piling of inferences here, because there's a whole host of conclusions that the jury needs to come to find that he had knowledge about what was in the car, and that includes that Mr. Hernandez knew what Mr. Paula was doing. There's a whole variety of different things that he could have believed.
You don't think that from the facts, the jury could infer that Mr. Hernandez knew that Paula was engaged in a drug transaction where he was the seller? That's your position.
I think that requires the piling of inferences, and that's the argument that's made in my reply.
Drives Paula to an area that's a known drug area. Paula gets out of the car. Paula engages in some sort of drug transaction in that car, and then is immediately found with 7 grams of, I forget whether it's heroin or fentanyl, on his person. And inside the car, they find 150 grams plus $1,100 in cash. And the jury can't infer from that Hernandez knew what Paula was engaged in.
So I think that the jury, that there is an equally available proposition that the jury could have concluded that Mr. Hernandez was driving Mr. Paula, as Mr. Paula testified, to purchase drugs. I think that
we can't consider what Mr. Paula testified to, because
I'm just saying that it's an equally.
Then we're going to consider the fact that Paula testified that he didn't put the drugs in the car.
I'm just saying that there's an equally.
You can't have both ways. Do we consider what Paula said or not?
We cannot consider what Paula said in terms of whether or not the Commonwealth met its burden. What I'm indicating to the court is that there is an equally available proposition, and when there are equally available propositions in terms of knowledge, that it's not sufficient evidence. And I think the more important piece here is whether or not Mr. Hernandez has the intention to exercise dominion and control. And here, there is absolutely no plus factor. So even if there is knowledge, that
well,
Mr.
one of the things we do look at, excuse me for interrupting, one of the factors that the courts look at is proximity. So certainly the drugs in the purse were within his reach, right? So we've looked at that as a factor before. That seems to be apparent by the state of the evidence, right? The purse was on the floor on the passenger side.
I would agree that it was on the floor on the passenger side, yes. But I would suggest to the court that there's no indication that he did make any reaching movement or any furtive gesture to suggest that he, even if he knew it was there, that he intended to exercise dominion and control. And I would point this court to the Romero decision from the Supreme Judicial Court, which in that court, the court does infer knowledge of the presence of the firearm, but the court says that there is no plus factor there to indicate any intention on behalf of the driver of the vehicle to exercise dominion and control. So even if...
With only 5 minutes left, though, if the panel doesn't mind, I was hoping that you would turn to the suppression issue.
Sure. So with
and you do, I'm just going to ask if you're familiar with Commonwealth versus Barretto, which was released around the time that these briefs were written.
I apologize, Your Honor, and I'm sure that I read it because I read the slip opinions every day, but offhand, I cannot recall the facts that, of that matter.
There were two cases, an appeals court case, and then the Supreme Judicial Court also ruled on it, and it had to do with a stop of a car and a so-called silent movie of a drug transaction. But in that case, the issue was whether or not there was reasonable suspicion to have the individual exit the automobile. In this case, the judge appears to have elevated the level of evidence needed here to the level of scrutiny here to probable cause.
Yes.
And I was wondering if you could explain that to me. And not to throw you for a complete loop, but why are we not examining this case as to whether or not the officers had reasonable suspicion to believe that Mr. Paula had been committing a crime? Why did they have to find, why did the judge determine that they had to find, that he had to find that there was probable cause? I'm assuming it's just because the minivan was parked askance and to the side of the Honda and blocked the Honda in.
So that's my understanding, Your Honor, is that probable cause was applied here and probable cause was required here because of the sort of intrusive actions of police in escalating this sort of typical stop to entirely impeding the ability of movement.
Why did the police need more than reasonable suspicion to do what they did? They see what they believe is a drug transaction.
Yes.
Right. Experienced officers see view what they believe is a drug transaction in an area known for drug activity. So if I'm looking at the 4 Santalese factors, you have the observation of an unusual transaction. The event occurs in a location where the police know drug transactions are common. You have an experienced officer on the scene that regards the event as consistent with a street level drug transaction. In Santalese, of course, what they used, the standard was a probable cause standard because of the nature of the stop. But here, all you had was an exit from the automobile, a pat frisk, which of course revealed the drugs. So are we now at this point, can we view this case as a case requiring only reasonable suspicion, or are we required to look at this case through the lens of probable cause?
I would ask that this court look at this case through the lens of probable cause, and I would point this court to Commonwealth versus Sanderson, which is a Supreme Judicial Court case 398 Mass 761, 1986 case that talks about where the police, sort of aggressively approach a vehicle and blocks in a vehicle with a show of authority, that can be a stop.
Exactly, but did that happen here? There are other cases in which just simply stopping the car and blocking it off so that a motor vehicle does not drive away does not constitute an arrest. There was only 2 officers. There was no firearms were displayed, correct? So
I agree that there is no evidence that firearms were displayed. That there just wasn't much evidence elicited here in terms of what happened as police approached the car. And I agree that there was no evidence one way or another whether or not firearms were displayed. But I would ask that
there was no. Let me just be sure. No one testified to drawing a weapon in this case, correct?
Correct.
Right. There is one more Santalese factor, which is more in your favor in this case, so I don't want you to think that I had omitted it intentionally, and that is whether there are furtive actions by the participants. But in this case, Mr. Paula anyway, and that's what we're really talking about because he was the one who was initially investigated, was sweaty and nervous, etc. So there was that additional factor, although there was no observation of furtive gestures.
Right, correct. And I would just ask, I know that I only have a minute remaining, but that the court look at the Commonwealth versus KIRGIZ case, which came out of the appeals court in April 2020, just in terms of that deals with reasonable suspicion, but also, I think that the facts are analogous here. And
Isn't the problem with KIRGIZ that the question in KIRGIZ would have been relevant if they had stopped your client who was just sitting in the car. But here the stop was of Paula, And the question is, what could they do with respect to Paula based on what they observed him doing?
Sure. So, but I think that the analysis in Kearse is on point. I understand that the defendant in Kearse is in a separate procedural posture, but the analysis in terms of what meets reasonable suspicion is.
Kearse doesn't deal with the question of whether they could have stopped the folks who had the handshake.
Right.
Now, maybe Kearse would have said they couldn't, but Kearse was one step removed from that. There was a guy just standing next to them or near them. That's what Kearse was about, was whether they could stop him.
So I understand that, but if I could just very quickly point the court to the quote about a quick handshake in a high crime area between individuals unknown to police, even when viewed by an experienced investigator, standing alone does not provide more than a hunch that a drug transaction occurred. And that's what I think is important. Okay, and I guess as to the remaining issues, I would rest on my brief.
All right. Thank you for fitting everything in a short period of time, but I'm going to check with the panel to be sure they don't have any more questions, because you did raise a number of issues in your brief. So Justice Sullivan, did you have anything else you want? Okay. Justice Englander?
No, I'm good.
Okay. All right. Now we'll turn now to the Commonwealth. Thank you very much, Attorney Cordignone. Attorney Mello?
May it please the court, Emily Mello on behalf of the Commonwealth. I would ask that the court affirm DILSSON Hernandez's conviction for possession with intent to distribute fentanyl. As to I'll start with the sufficiency of the evidence issue.
Actually, if you don't mind, could you, and maybe if you don't mind, could you go to the back? Could you explain to me why the Commonwealth takes the position that it was necessary to have probable cause to search Mr. Paula and remove him from the car rather than just reasonable suspicion? It seems to me from the motion to suppress that the issue was not really litigated, and since the Commonwealth didn't file a brief there, I'm not really sure what the Commonwealth's theory was of the case, but the judge, of course, applied the standard of probable cause.
Yes, and I think that was the correct standard to apply in these circumstances, only because, sure, reasonable suspicion may have been enough for stopping the vehicle and getting Mr. Eddy Mr. Paul Eddy out of the car, but they did also frisk him. And in order to do a frisk, he would either need to believe that he was armed and dangerous, which I don't believe we had, or in the alternative, have probable cause. So at the end of the day,
what about the case law that says that if you have reasonable suspicion that someone has committed a crime and then they act in a manner that is consistent with that, the sweating and a nervousness that Mr. Paula exhibited, that would not justify a pat frisk in your view?
I think that the court could certainly find that there was testimony that Mr. Eddy was acting extremely nervous. I believe he even called him an ambulance because he was acting so oddly. And I do believe that under those circumstances, he could pat frisk him. So if there was to look at that particular analysis, then the reasonable suspicion for stopping the vehicle and getting him out of the car, and then the pat frisk based on Mr. Eddy's actions and the sweating and the nervousness, that could be another justification for the stop. And sure.
How would you get around Torres Pagan if you took that position, counsel?
I think that the court would have to infer that he had a reasonable suspicion that he was armed and dangerous based upon his demeanor and the way that he was acting.
Okay.
But the Commonwealth would also argue that there was, in fact, probable cause at that time based on those Kennedy-Santeliz factors. And I think we had more here than just a high crime area.
You mean probable cause to arrest, right?
Mm-hmm.
And here we have more than, a lot of times the officer just testifies, oh, this was a high crime area, this was a high crime area. But here the officer testified to more than that. He said that he had made several arrests recently in that exact spot for drugs. And the last shift that he worked, he had made an arrest for distribution or trafficking in heroin, over 200 grams. in that area. So I think that based on those facts in combination with the actions and what was viewed by the cop, that he
Was
did in
viewed by
fact.
the cop, if I may, and correct me if I'm wrong. What the officer sees is that Paola goes from the car with the defendant and starts to walk away, comes back, and then goes over to the other car, and they don't see any exchange. They don't see what happened when his hands go in the car, and when he leaves, they don't see anything in his hands. So they don't see anything in his hands going to, coming from, and they don't see what happened in the car. Are those, have I correctly stated the facts?
Yes, that's correct.
All right. So we have an area of high drug sale and an interaction between men in two different cars. What is your best case for the notion that that arises to either reasonable suspicion or probable cause? And I will say that I read the Montoya case, and the Montoya case has other facts in it.
It does, indeed.
All right.
I would say that Kennedy and
Barreto, because we said, and the SJC agreed in Barreto, that if you don't see anything in the hands and you don't see anything going back and forth, that there are many innocent explanations for this. Could be a transfer of something else.
Sure, and there could be innocent explanations, but there are also cases, and I would point the court to, I think Kennedy and Santeliz, and really those cases are the seminal cases on this type of activity. And in Kennedy itself, they say that the quickness of the interaction reasonably could be interpreted by the officer as suspicious conduct. It's not that there aren't other potential non-criminal reasons to act in that way. It's whether the officer could have made that inference. And I think that he could have, based on the fact that it was a high crime area. He had just made an arrest there.
Isn't it significant that this was clearly an arranged meeting that was very oddly done?
Certainly, and it was an out-of-state.
It stops. Another car comes and stops very close to it. The person gets out. They go to that car. They're there for seconds. They leave. Were those facts present in Barreto?
I'm not sure about the exact facts of Barreto, but I would say that all of those facts together amount to probable cause. And I would say, in addition to the facts that Your Honor listed, the fact that it is not without significance that Eddie Paula gets out of the car, he sees the undercover vehicle, and he actually makes eye contact with the cop. And then he goes back to the car and speaks with Mr. Hernandez. And then he proceeds over to the vehicle with the Arizona plates. And I think that the cop could have made the inference, I think the jury could also make the inference, that he was going to engage in the transaction. He saw the police, he became nervous that they may in fact be police, and thought about not doing it, and then did. I think that also adds to the probable cause analysis.
But then he did it, so how is it consciousness of guilt? I mean, he went forward.
Well, he spoke with Mr. Hernandez, and I think that the jury could infer, and the cop who's watching this could infer, that Mr. Hernandez said, no, go ahead, and then he did.
Well, we don't. What was the evidence that they actually spoke? Leaving aside Paula's evidence, because that wasn't available at the suppression period, and it wouldn't be available. I mean, what's the evidence that they actually spoke? The evidence is he leaned back in the car, right?
I believe the evidence was that the officer saw him lean into the car and speak with whoever was also in the car.
The officer could see him speaking.
That was the
I
testimony.
think that may have been what the testimony was, and unobjected to. So maybe that's what we've got.
That was, the officer testified that he, and I think that you can. I think if you see someone leaning into a vehicle, you can see that they're, you're driving by a car and you see someone leaning into a vehicle speaking with the person who's operating the vehicle.
Or at least it's a reasonable inference, and it would certainly go to sufficiency because it puts Hernandez in the middle of the chain of events. But we're on suppression right now.
I think it helps with both.
The Barreto case creates an interesting set of issues with respect to how we should view Kennedy and Santalese. It cites with authority an older case of ours, Commonwealth versus Clark, and it says the following in a parenthetical, and I just wanted to give you the opportunity to respond to it. Clark, no reasonable suspicion for stop where individual in a high drug area left a bar, approached defendant, handed an item to defendant, and then returned to bar as defendant appeared to count money. In that case, we said there was no reasonable suspicion, and the SJC just quoted it with authority or cited it with authority. How would you respond to that given the facts of this case?
I think that's very different from what we have here. And I think a lot of the facts that Justice Englander had mentioned, the fact that this was an area, I don't think Justice Englander mentioned this specific one, but the fact that the cop had just made an arrest in that area for drugs, and then the whole setup of the transaction. It's different than someone just coming out of a bar and having a quick interaction with someone. The fact that the car shows up, minutes later, the other car shows up. It's that whole silent movie that they talk about in Kennedy and Santalese. And that's what sets this case apart from those line of cases like Barreto, where they say that the quick interaction is not enough. We don't have just a quick interaction here. We have the entire setup and the entire facts as they play out in the eyes of an experienced investigator.
So the difference in the bar case would be that the police officer is not sitting there watching the entire silent movie and seeing an obviously arranged meeting in a high crime area that is very odd, where people come together for a very brief period of time and then leave, right? That's the difference that you're talking about?
Correct.
Well, except in Barreto, there was a tip and they set up surveillance and they were watching this car to see if people would approach it.
I'm not sure if that tip was verified.
It wasn't, but if the distinction that we're drawing is whether or not this was an active surveillance to see if there was a meetup, the Barreto is more along the lines of the meetup than the chance encounter from a bar, if we're drawing that distinction. That's all.
Yeah, but I'm sorry.
It's tough. It's a tough issue.
Sure. You have to look at all the facts of the case and make a determination. There are always going to be cases on both sides that come down in different ways. I do think, though, that although they had that information in Barreto, where if the tip was not, if there was no basis of knowledge or veracity established, then they wouldn't have really been able to use that in their analysis.
No, but it was a surveillance situation for whatever reason.
Sure.
So let me just understand that for a moment. I understand that you're telling us what the law is and not necessarily what the Commonwealth thinks the law should be. But what I would draw logically from what you just said is, if you have a tip that something's going to happen and that's what places you in that position, you can't rely on the tip. But if you know that an area is a high crime area and you choose to be there, not having any specific reason, that's more of a basis for cause than if you actually had a tip.
Only if that tip is not verified in any way. When it's the officer's own knowledge, then obviously he has the basis of knowledge and the veracity, and that's not something that the Commonwealth would need to establish, where if it is a tip coming from an informant, it is something that the Commonwealth does need to establish.
Well, now you're down to 2 minutes and you didn't get a chance to address the sufficiency of the evidence like you wanted to when you began your argument. But if I can, with the consent of the panel, could you address that now?
Sure, absolutely. And it's a similar evidence presented at the trial as there is at the motion to suppress. And I would say that the Commonwealth certainly had sufficient evidence here. The case obviously was stronger against Mr. Paula, but there was sufficient evidence to infer that Mr. Hernandez had knowledge and the intent to exercise dominion and control over those drugs, where he drove Mr. Paula to this area where there is known incidents of drug dealing, and there is that purse, which is, I think the testimony was, it was loosely covered with thin tissue paper. I think, and then the transaction takes place. And also the fact that Mr. Paula goes to make the transaction, comes back to the car, speaks with Mr. Hernandez, and then consummates the transaction. And I think that based on all of that, the jury could have inferred that Mr. Hernandez had knowledge and intent. And if there are no further questions as to the other issue.
What's your best case on sufficiency?
I would ask the Commonwealth I would ask the judges to look at Commonwealth v. Krabs, and it's not that which is 84 Mass Appellate Court 442. It's not that the facts are the same, but it's the overarching concept that they talk about the defendant's proximity, access, and collateral conduct all permitted the inference of the intention. And I think that that's what we have here. We have that collateral conduct and the entire course of action, which allows the inference.
I have one minor question for you, but I'm going to check with the panel first to see if they have any questions about the substantive issues. Judge Sullivan or no? Judge England or no? If it's on the record, I didn't see anything in the record to answer this question. So if I missed it, maybe you could illuminate me to the reasons why the Commonwealth no-prossed the trafficking aspect of this indictment.
So that's because when they first came out with, and I apologize, I should have dropped a footnote about this. And I don't think it was actually, the reason I didn't drop a footnote is because it wasn't mentioned in the record. But when the fentanyl statute, the trafficking in fentanyl statute first came out, the phraseology was reversed in a way that
there was some reference to the statute from the prosecutor in the beginning. And so that was the case. It wasn't some infirmity. All right.
Yes. So until they fixed that statute, we could not actually prosecute that charge. And that was why.
That's all right. Just wanted, thank you very much for clarifying that.
I had one question. I'm sorry if it's okay.
Yeah.
The question that was asked on cross-examination of Paula, does the defendant deal drugs? That was an improper question, right?
I think it did have some basis in evidence. It was certainly on the line. Based on Paula's answer, there wasn't any prejudice.
There's some basis in the evidence, meaning, but when you say, does the defendant deal drugs, that's not a question, was the defendant dealing drugs on this occasion? That's a question about character or past behavior. How could that possibly be a legitimate question?
Well, it was phrased in the present tense. I'm not saying it was a great question. I do think there was some basis in evidence, and there was certainly no prejudice based on Paula's answer that he did not know.
Well, no, that's not true, because then your prosecutor took that answer and argued it in closing. So to say there's no prejudice, it seems to me, is quite a stretch.
But the argument that was made was had nothing to do with Mr. Hernandez. The argument was, is it believable that Paula doesn't know that his friend that he's known for 5 years doesn't know whether he's a drug dealer. So that argument
The
was,
inference that was intended by the question, which is that the defendant is a drug dealer, and then he took it and he argued it to the jury.
well, he argued that
I'm
Mr.
not sure I accept, there was no objection, and I think that's the biggest problem with it. But I don't know that you can ask that kind of question.
Okay, I think we'll close the argument at that, and we'll try and figure out whether or not we will decide at some point whether you can ask that question or not. So you can be assured of that. Thank you both very much for your arguments today. We appreciate it, and on behalf of the panel, we wish you that you and your family stay safe and healthy during this challenging time. Okay. To the beginning of the court term. Let me start by introducing the panel to you. I'm joined today by Justice Mary Sullivan and Justice on term. Let me start by introducing the panel to you. I'm joined.
Sorry.
One moment. I think we have just a little bit of a glitch.
I think it's okay. I had left YouTube on by mistake.
Oh, okay. All right. Well, there we have it. Perfectly okay. I just introduced the panel to you, and I was going to thank you all for participating remotely. And my next comment was going to be that we may have some technological difficulties. And that's our very first one. If that's all we have, we'll be doing just fine. So we ask for your patience should that happen on our end, and we will be patient with you should it happen on your end. Before I begin, I want to remind you that the regular rules of appellate procedure apply. I understand that both the parties here have split their time on both sides. Each attorney will take 7.5 minutes. And of course, there is no rebuttal. So I'm going to call the case now, 2019-1450, Department of Children and Families and Another versus Mother and Another. The case, of course, is impounded, partially impounded, and this is public. So please keep that in mind when you refer to the parties, okay? Are we going to start with Attorney Foster or Attorney Katz?
I thought Attorney Katz, but.
Oh, okay. Good morning, Your Honors. Daniel R. Katz for the mother. I would like, Your Honors, as we review this case, to keep in mind a declaration that the Supreme Judicial Court made almost 30 years ago in adoption of Carlos. And that was, and I would like to read it to you if I may, the natural bond between parent and child should not be permanently severed unless the child's present or future welfare demands it. And I would like you to keep that declaration in mind, because this is a case where I'm arguing that termination was not in the best interest of this child. And now let's look at the connection between the mother and the child. Certainly the mother has struggled with substance abuse, housing instability. There were some criminal issues which were unresolved, and the relationship with the father. One thing that has been constant with the mother is her relationship and the affection between the mother and the child. And I know that the appellate court gives deference to the lower court's findings because the judge is sitting there observing the witnesses. In the same sense, I'd like your honors to consider that when the social workers get up on the stand or submit reports, they are the ones who have been there, and especially in this case, when I'm hoping to concentrate your honors' attention on the connection between mother and child during the visits, they are the ones that have been there. And what has been constant, despite the relapses that she's had with drug issues, is the affection, the observed affection between mother and child. Her consistency in not only attending the visits, but participating in them, not just participating in a so-called appropriate way, which we often see in findings or descriptions by social workers. Oh, the parent acted appropriately with the child. But here, what I would like your honors to concentrate on is the affection during the visits between the child and the mother.
Counsel, if I could interrupt and try to direct this to what, I don't think you're misrepresenting the record at all. And I think that the judge found this, and this is what was testified to. But the question, it seems to me, is whether that's enough. You have a stipulated unfitness, which I don't see that you are contesting. You have, I think, I don't really understand you to be contesting any of the facts found by the judge, which include that the mother was, she had a substance abuse problem which was not being addressed at the time of trial. So as I understand it, you have this, the law says for termination that you need unfitness and you need no reasonable likelihood that that is temporary. That's one way to look at it. And wasn't it within the judge's purview, given the facts as found, to reach that conclusion, and therefore that adoption was appropriate?
I think, Your Honor, what I'm hoping Your Honor will look at is the second part of that consideration in terms of is termination in the best interest, is the situation of the child regarding the department's plan. And here, in the cases which I've cited in terms of when this court has found, oh, this is one of those situations, not necessarily common, but this is one of those situations where termination is not in the best interest. And here we have a situation where at the time of trial, the caretakers were not yet approved as an adoption resource. And I think that's one factor that comes into play in terms of what is the current situation. And that also includes the cases have talked about, is there a sufficient or is there a strong bond between the child and the current caretakers?
What's our standard of review for the conclusion that termination is in the best interest? What's our standard of?
It is an abuse of discretion, Your Honor. But in terms of looking at that, then, what are the factors that go into that consideration? And here, there was, yes, I'm not disagreeing with the facts that were found by the judge, because I'm not arguing that the findings were clearly erroneous, but the fact that there should have been consideration in terms of the current situation, either in terms of a bonding, like here, there was no evidence, absolutely zero evidence of any kind of connection between the child and the caretakers. And in the cases in which this court has found that termination was not, or that either the judge correctly decided that it was in his or her discretion to not terminate, or that there should not have been termination, this court has looked at, well, what is the connection, not only the connection between the child and the foster caretakers, but what is the status of that placement?
The
And
paternal grandfather testified at the hearing, right?
there were, yes, but what I'd like to impress upon Your Honor is that the adoption social worker said that at the time of trial, and of course, that may of course change since here we are now, but it was not a definitive adoption resource yet, because he was living with the paternal grandfather and the paternal step grandmother in New Hampshire, but it had not yet made that step to an adoption resource. And if you look at what I find interesting about adoption of Bianca is that one of the factors that the court considered in terms of why termination was in the best interest was there was evidence that there would be harm to the child with any kind of, oh, my time has expired, any time of disruption to the child. And here, not only do you have a healthy child, but there's no evidence there's no evidence that there would be any disruption to the child for not having a termination. Because I know the cases talk about, well, children need stability. And of course, that is correct. But here, this is not a situation where the judge could make a connection between the need for stability. There was no expert testimony, not that there needs to be, but there was no expert testimony or evidence like there was in Bianca that any kind of change would be severely disruptive to the child's welfare. So I think you have that.
Now your time is up, and I've just given you a little bit of extra time to finish your point, which of course we appreciate, but I'm going to have to stop you there unless anyone in my panel has specific questions for you. Now, thank you very much, and of course, everything you have in your brief will be considered. Okay.
Thank you, Your Honors.
You're welcome. So now I'm going to turn to Attorney Foster.
Thank you, Your Honors. I'm Attorney Catherine Foster. I'm appearing on behalf of the father in this case. I would agree with Mother that termination is appropriate when it's the best way to ease a child's path to permanence, when the children have special needs that the parents can't meet, or where the child has no relationship with his parents. But what about when a child is closely bonded with his parents, with his father? What about when that child is typical, healthy, and has been raised in the continuous care of his biological family members? And what about when the proposed kinship placement prefers the same lesser alternative available under the statute to what this court describes as the extreme step of termination? The court erred by not conducting a more searching inquiry into the child's best interests. Each of these cases is very fact specific and requires a careful evaluation of the facts regarding both the child and the family. And here, DCF's plan was actually rather extreme. They proposed to this child's grandparents that if these grandparents didn't agree to specifically adopt their grandchild, not guardianship, no other option, that they would put his picture in basically a catalog and allow him to be shopped for by pre-adoptive parents. So of course,
why is that? I struggle. I saw that in your brief, counsel, but I struggled with why that matters, given that family members chose to adopt. I mean, is this we're concerned about what DCF's strategy was?
Well, I think so.
Why does that matter? Why does DCF's strategy matter under the circumstances? I don't hear anyone saying that the paternal grandfather is an inappropriate placement for the child. Do I?
Well, no, that's not the issue, though. The issue is whether it's in the best interests of the child to terminate the legal relationship that he has with his parents, especially when it's not necessary to ease his path to permanence. He could have had the same level of permanence under another option in the statute. In fact, in both 119...
Was there evidence on that at the time of the hearing? Was there any evidence about whether a guardianship would have satisfied, whether they would have been able, DCF would have been able or would not have been able to achieve what their goals were with a guardianship by the paternal grandfather?
It's clear under the statute, both 119.26 and 210 section 3, that not only is guardianship an acceptable form of permanence under the statute, but that
question though, was there any evidence on that? I mean, we don't know, as I understand it, whether the paternal grandfather might have said, I'm not interested unless it's an adoption.
Actually, the paternal grandfather's first choice was to be a backup rather than to be the primary caregiver.
But in the end, they were prevailed upon to adopt. And the judge has a specific finding that the maternal grandmother, who was what was proposed, is not acceptable.
But that still does, I'm sorry. But the question still remains whether termination is in the best interests of the child. The court could have found both parents unfit and gone from there. The court didn't have to terminate. And in this case, if you look at a case like adoption of Nancy, the SJC said, okay, you can terminate, you can terminate parental rights in the best interest of the child. But on those facts, the children had severe behavioral needs. The children were dysregulated around visits. They hadn't lived with their father. There were no other alternatives. In that case, the SJC said it's appropriate to terminate because otherwise these kids won't have permanence. But even in that case, the SJC said that made a point of finding that termination is not a prerequisite to permanency. And
Well,
so
Can we turn though a little bit more to the facts of the particular case involving the father? I take your point that there was evidence of a bond with the child, but the father had been unavailable to the child for a significant period of time because of his incarceration. But even leaving aside the incarceration, which in itself, as we all know, is not disqualifying, there was a history of domestic violence here and an absence of efforts by the father to avail himself of substance abuse treatment, therapy, psychological evaluation, or what we used to call batterers programs, but violence reduction programs. As you know, we have many cases involving domestic violence where that is a critical factor in the termination decision. Could you address that?
yes, Your Honor. The relationship between the father and the mother was indeed turbulent, but it was unrelated at that point to their relationship with their child. They weren't parenting together. And even, so I'll leave it there. And also, they don't contest. I'm sorry.
But if he is an individual who has engaged in domestic violence, is that not something that the fact finder may take into account?
Of course, in finding unfitness. And father doesn't challenge that he was unfit at the time of trial.
Also in finding whether in the future there's a potential for neglect, which is a finding this judge made, that the domestic violence and the inability to address the domestic violence meant that there was a potential for future harm to the child if the parental rights continued. Is that, am I misreading what the judge did?
No, father's not contesting unfitness. He's contesting whether it was in the best interest to terminate his parental rights to his child, or whether it was in the best interests of the child. And I'll point to the fact that up until trial, the child had monthly in-person visits with his father, where sometimes he would sit on his father's lap and hug him for the whole visit. He had weekly phone conversations that the child looked forward to. And that according to adoption of veto, so looking at not only best interest, but also the issue of the visitation order, the best interests of the child, if they have an ongoing relationship, is served not only by not terminating potentially, but also by a more expansive visitation. In this case, you have a child that miraculously was not traumatized by his limited interaction with the department, but you have a child who had regular contact with his father. It's incumbent on the court, when looking at these kinds of relationships with a child who has not been traumatized, not to take a typical child and subject him to potential trauma by terminating all relationship with his parent. And I'll rest on my brief for the rest of my arguments. Thank you.
Thank you very much. So we're going to turn now, take it there's no further questions from the panel. Okay. I'll turn now to the department and Attorney Furgan. You're on mute.
Hopefully
There
you
you
can hear me now.
Yes, we can.
Excellent. I'm going to depart from my prepared remarks because your honors have already addressed many of the issues which I would have used as an introduction anyway. And I'd just like to focus on the situation faced by this judge and any judge dealing with this type of a hearing, which is that the judge has to make a literal judgment call on what is likely to happen in the future based on the events that have already occurred. And that's always a difficult decision. And that's the reason why the appeals courts defer to the judge's rulings in general and rely on the abuse of discretion standard. And here we have a situation where there really was no dispute on the facts that the judge had before him in attempting to make that prognostication on the future. And the facts were, as the court is fully aware, that the parents repeatedly conceded that they were unfit for multiple reasons, both on the mother's side and the father's side. The judge did acknowledge the fact that there was indeed an ongoing bond that the child had with both parents, but the judge's concern, and properly so, was what would be in the best interest of the child for the future. And the best interest in the court's discretion was that the child, the parental rights be terminated, and that the child go forward with the adoption program that was suggested by the department. And that would be hopefully that the child would stay with his parental grandfather. He had been with parental grandfather for 5 months at the time of the trial. He had a relationship with the parental grandmother for quite some time before then because of weekend visits. And so on those circumstances, the judge properly decided that the right course was to terminate the parental rights of the parents, allow the child to continue with his integration into his parental grandfather's family, and that the best way to do that was to, as the courts say, only allow limited, allow visitation only to the extent that it was necessary for the child's integration to succeed in his newly adoptive home, or at that point, hopefully adoptive home.
Okay,
And
can I stop counsel and just, because this is something that has come up repeatedly in the very short time that I've been doing this business, and I struggle with it every time. I don't think anyone contests that for all of their faults, the parents made their visitations when the visitations were available, and that the visitations showed a bond, particularly with the mother, I think, but with both parents. So then we have a decision that says, well, it's not going to change and an adoption is necessary. And now you can see the child once for 2 hours every year. And the question I have is, what cases would you send me to really understand what a court needs to do in addressing the question of post-termination visitation? Because you just said, as it shows in the cases, and I'm familiar with some, and I'm not sure they're all consistent on this point.
Well, you are right. As I am before the court, I can only refer to the cases cited in my brief on the issue of visitation. I believe there's the adoption of Warren case. There's also, I think, the adoption of Vito is another case that goes into some detail about visitation of parents. And also LL versus Commonwealth is another case that deals with the frequency of adoption. And again, it is obviously a difficult decision, and one that the judge was fully aware of at the time that he made the decision. But I believe he followed the dictates or at least the recommendations and guidelines set out by the SJC in those cases, which is
Well,
that
he doesn't
one thing
cite
to
any
allow-
cases. I mean, if you look at what the judge, it's a very detailed and well thoroughly thought through order, but he really doesn't explain how he says an order of visitation is required to serve the best interest of the child. That's a finding, page 42.
Yes.
And then the next sentence is 1 visit for 2 hours every year. And I don't see any citation to cases or any discussion in that as to how he got from one sentence to the next, if you will.
Well, I would, well, it's not explicit in the findings to that degree, but the court's actually, decisions actually don't require any visitation at all when there's a termination of parental rights. And the judge here went beyond that and decided to mandate at least one.
I understand it is that once you've decided to terminate the parental rights, you want the adoptive parents to be able to be heavily involved in the decision-making going forward. Is that part of the reasoning that's in the cases?
That's exactly right. And there is testimony in this case that the parental grandfather committed to allowing family visits going forward based upon the guidance that he was provided by the department. So there's a difference between, it's not that their parents cannot visit the child from this point forward, but rather that now that the child will have a new adoptive family, it should be up to them to make the judgment of what is in the best interest of their child now, whether or not to allow more than one visit, and what the frequency should be and what the character should be. And the parents have committed to that. And the other interesting element here is that we have the misfortune in a way that has taken 2 years, but it has now been 2 more years since that order. And we now see that the child, through his attorney, has changed his position on the matter of visitation and is now asking the court to uphold the order of the judge. And although, again, there's no more evidence, and there cannot be, I think the actual change in position of the child does speak to the correctness of the judge's exercise of his discretion on that issue.
So your time's expired unless the panel has any further questions of the department. I see none. Okay, thank you very much. We'll now go to the attorney for the child, Attorney Vaccaro.
Hello. On behalf of the child, I am asking this court to uphold the lower court's decision regarding its decision to terminate parental rights, to approve DCF's adoption plan with paternal grandfather, and to also uphold the order of visitation for each parent 2 hours each year with the child. Now, this being said, you know, when this case came to trial, these parents were not visiting with this child once or twice a week. They were having once a month visits at this point, and there were some phone calls too. I know that when the child was placed at the paternal grandfather's home, there were phone calls by the father and by the mother allowed to happen.
You're going outside the record now. This is after trial, after the order?
Actually, there's testimony and record evidence of the father having phone calls with the child. And those occurred at the paternal grandfather's home.
I don't know if you're going to be able to answer this question based on the record we have, and if you can't, that's fine. But can you account for the change in position between trial and appeal?
The grandmother's testimony, the maternal grandmother testified at trial, and there was some concern about her testimony. And actually, it was part of the findings. that the judge did not find that she was credible regarding stability of her daughter. In fact, she had said that she had lived with her nonstop, with the exception of the time when she went to a shelter for about 5 or 6 months. That's not true. The mother and the maternal
below. Did you represent the child in the trial court?
No, I didn't. The maternal grandmother and the mother apparently had problems because the mother with the child would move back and forth in between maternal grandmother's home, paternal grandmother's home, and relatives. So there was really no stability there before DCF got involved. The child's stability actually came when DCF got involved, and then the child went to live with the maternal great-grandmother for 3 years. There was another concern of the trial court judge, and this is also noted in the findings, that maternal grandmother had a partner who had a felony conviction 15 years before the trial, 13 years before the trial, something like that, and that the grandmother really knew very little about that. So I don't know where I'm going. And can we go back to what was your original? Because you directed me to give some of these reasons for a specific reason.
Resume your argument. Thank you.
If I could, maybe I'll jump in. I take it that Counsel Fergang's statement that the child does not challenge the visitation order on appeal is correct?
That is not challenged. And I will say it's for this reason, that the paternal grandfather made clear, and this is a part of the record, that he wanted family to be involved and that he would cooperate with DCF in making sure that the child's contacts, not only with parents, but with maternal great-grandmother and maternal grandmother, were continued. So this is a case where everyone loves this child, and it's to his benefit that he's able to interact with members of his family so long as it's in his best interest. And so long as his parents are doing well. They had substance abuse issues, domestic violence issues. They had a lot of issues that really were never resolved by the time the trial occurred. So the judge was in a position where he had to agree, and the parents have not contested that the parents were unfit, that their unfitness would be enduring. And the trial judge basically made a decision to place this child in the most stable environment, and also in an environment that will be cooperative, that will be meaningful for the child in the sense that he will be able to continue family contact. And the decision.
I apologize, counsel, for this. In every one of these cases, it seems like I struggle with what I'm about to ask, because it arguably goes outside the record, and if you're not comfortable answering it, you can tell me so. But Judge Sullivan has put her finger on the concern that I have, which is your prior counsel took a position regarding where the child should be placed that is not consistent with the position the child is now taking. Is the position the child is now taking based on recent interaction with the child, or is it based entirely on the record that was developed at trial?
Okay, I am going to say that trial counsel presented maternal grandmother as a guardianship possibility because she at that time was very involved with the child's life. In between the trial and the testimony at trial and the decision by the judge in the trial court, which was made on January 7th, and the period of time in which child would take the appeal, Child's counsel in the lower court decided not to appeal and to go along with the decision that was made in the judge in the best interest of the child.
Okay, thank you.
I don't have a time thing up here, so I don't know if I'm running
24
low.
seconds.
Pardon me?
20 seconds left of your argument.
Just enough to ask this court to uphold the lower court's decision. It is in the best interest of the child, and the child does support the adoption by the grandparents, the paternal grandparents.
Well, on behalf of the panel, I want to thank all of you very much. These cases are always very difficult, and you can be assured that we will give it our utmost attention. And at the same time, on behalf of the panel, before we close, we want to wish all of you good health. We hope that you and your family stay safe, and we look forward to hearing you in arguments in the future during this. Welcome to this, the beginning of the new term of the appeals court. I'm going to start by introducing my panel. I'm joined by Justice Mary Sullivan, Justice John Englander. My name is Ariane Vuono. I would like to thank the court staff again for their incredible help in assisting us in being able to hear arguments in this remote platform. And I thank the both of you for participating virtually. We may have some technological difficulties during the course of the argument. We hope not, but if we do, I hope you'll be patient with us, and I can assure you that we will be patient with you as well. The usual rules of appellate argument apply to virtual arguments as well as just as if we were in the courtroom. So each side has 15 minutes. There is no rebuttal. We've reviewed everything that you have submitted to us, so please feel free to get right to your best argument when you begin. I'm going to call the case now. Jerome Manning versus KIRGIZ Realty and others, 2019-1474. And the appellant is Attorney Fencer, correct?
Yes, Your Honor. Good morning or good afternoon, Your Honors. Your Honors, I'm going to just address a couple of points in response to the appellee's brief, and I hope to be helpful in helping the court claw back some of its time today, and largely rest on the brief. Your Honors, the appellees argue in their brief that the trial court correctly denied the J&OB motion because the damages were not speculative, and it focuses, the appellee focuses on the quantum of damages and argues that the defendants, the appellants here, waived those arguments. I think that the appellee misunderstands the defendant's arguments in this regard. The damages in this case, this is, as you know, a case on a breach of contract on a failed auction contract. The damages the defendant contends are speculative here, not because of the amount of the value of the property, rather, but that it was speculative that a sale would ever close. The defendants don't really quibble with the value of the property and the quantum of the damages being computed on that. $650,000 offer roughly approximates the assessed value of the property, and under the statute and the case law on assessments, the assessed value is supposed to be as close to fair market value as possible.
Counsel, it's Judge Englander. I'm struggling with this argument, and I need to understand what you're saying. So I'm looking at your statement of issue number 1. No reasonable jury could find, based on the evidence admitted, that any damages caused by a breach of contract were proven to a reasonable degree of certainty. That's the issue that you're raising. Your brother says that issue was not presented to the court on a motion for directed verdict at any time. Is he wrong? And if so, I need to understand why.
No, I don't think he's incorrect about that, Your Honor, but the issue that was presented in the J&OB motion was whether or not the jury could have found that there was a breach of the contract. And that's the issue that I'm trying to get to, is the issue of entitlement. What was very dubious about this transaction, in particular for the Revere property, with a bulk of the damage.
Okay, I think I understand what you're saying, which is you want now to raise on this oral argument the question of whether they could have found a breach. But I didn't read that in your brief.
No, Your Honor, it would have been something that I would have raised in a reply brief, but I was attempting to keep the docket of the case. This is a fairly pedestrian breach of contract case with not a lot of zeros on the end, and I was attempting to keep costs proportionate to the efforts of the client and the burden on the court to review all of the replies. So I felt that I would address these issues in response. But the issue that you just touched upon, Judge Englander, was raised in the JNOV motion that was denied by the court. So I apologize if I'm coming out of left field on this point.
That argument is, let me try that argument, and then you tell me whether I'm right or wrong. That argument is where there was no sale. Under those circumstances, at least with respect to this contract, there could not be a breach of the contract found with respect to your client. Is that basically it?
With the one additional gloss that, in addition to there not being a sale, that it was highly improbable that there would be a sale at that price, because the record contains evidence that the property had substantial environmental issues, as well as issues about code enforcement tickets. So the probability that a sale would have closed was an open question, but also a further probability that if a sale did close with Isaac's moving, that it would be for $650,000 that was offered. So that, Your Honor has correctly.
Talking about the Revere property now?
I'm sorry, Your Honor?
You're talking about the Revere property?
That's correct. The record reflects that the efforts at Natick were abandoned early on because the value of the property was not as high as the value of the Natick property, and everybody, from what the record gleans, and I was not trial counsel in the case, but from what the record reflects is that the auctioneer and the seller both agreed that the Natick property was not going to bring sufficient proceeds to warrant the auction efforts. That's why there was only $10,000 worth of damages allocated, excuse me, to the Natick property and $57,700 discreetly assigned to Revere.
We don't know what, we can't speculate as to what the jury did. So I went back and tried to read the contract, and my difficulty with this contract is it appears that the plaintiff is correct that your client was obligated to go forward with a public auction of these properties. There's no out for your client, is there?
Well, Your Honor, as Mr. Ozdemir wrote to the auctioneer in Trial Exhibit 38, which is in Record Appendix 2, it's an important exhibit because it's the predicate for the 93A. That's at Volume 2, page 106. He correctly notes that this was not an agreement into perpetuity, and it was not an irrevocable auction agreement. That's the situation in the Wisconsin case.
Wait a second, what do you mean it's not an irrevocable auction agreement? Where is it in the auction agreement that your client had an out and could just say, I'm not going to sell?
The auction agreement stated that the auctions would be conducted in October of 2016. It's akin to many brokerage listings agreements.
Your client came along and said, oops, I made a mistake. There are a couple things you need to know about these properties. And there was an agreement to postpone, but not an agreement to not have them.
Yes, but the agreement didn't also give Manning the exclusive right to sell this property into perpetuity.
The argument is an interesting one, but is that an argument made in your brief?
It is not, Your Honor. It was an argument made in the motion JNOV, and I am admittedly responding to arguments made in the appellee's brief at this time.
And in fairness, I should just say that typically we are not obligated to address arguments raised for the first time at oral argument or in a reply brief, even if you hadn't had one. And I appreciate your efforts at economy.
I understand what you said, Your Honor, but I'm obligated to use whatever arsenals I have in my.
Understood. Understood.
So essentially, Your Honor.
Go very well.
Mhm. So essentially, Your Honor, the speculation argument is predicated on the high improbability that the defendants contend that a reasonable jury could not have found that a sale would actually close and close at $650,000. And it's the defendant's position that it was error for the judge to let that issue go to the jury. Unless the court has any other questions on that particular point, I'll turn to the other point that I was going to address in oral argument, which I can assure the panel is included in our brief. And it is the issue of the amount of attorney's fees awarded based on the 93A finding.
Okay, can we back up for a second? I'm sorry.
Certainly, Your Honor.
You weren't trial counsel?
I was not, Your Honor.
Okay, here's what I'm struggling with on 93A. 93A is not a jury issue, right?
That's correct, Your Honor. The trial court, it appears, used the jury as an advisory body with some special interrogatories in the verdict.
All right, let me stop you there. Where in the record and how do we know that? Because my problem is this. Your argument is essentially another J-Mall argument. Or I mean, you were going straight to the attorney's fees, but you also make an argument that is you can't find a 93A violation on these facts. And if you're right about that, there'd be no fees. And my question for you is, how is that argument raised when the issue was sent to a jury? And I don't know what the state of the record is as to whether that was tried by agreement, whether there was ever an objection to it, whether there was any briefing on the subject, or whether or not the judge said it's, as you just said, an advisory jury. How are we to address the record on that? Or should we ignore it and just go straight to the fees?
Well, Your Honor, I don't believe that there was, to be candid about my understanding of the state of the record, I don't believe that there was any objection by the defendant's trial counsel to submit the questions about the 93A to the jury. And the jury's verdict slip, Your Honor, is in Record Appendix Volume 1, starting at page 72. And it covers both an allocation of the damages and its special interrogatories about whether or not, after instruction by the court, whether or not the defendants committed any violation of 93A. I want to point out that Mr. Ozdemir was the counts against him for the breach of contract, quantum merit, and implied covenant of good faith and fair dealing as to Revere were dismissed.
Do you want us to address the issue with respect to whether Chapter 93A was violated on the record here, or are you waiving that issue?
No, I'm not waiving that issue, Your Honor. I was standing on the brief for that point, but I do, since you've raised it and you want to discuss it, I'm happy to.
I want to know how you preserve that. Is it just like the other issue? Did you have to raise it on a directed verdict, given that the issue was presented to the jury? Or because ordinarily there'd be some separate briefing on Chapter 93A, and we would be able to look at that to see what was relied upon for the basis of the Chapter 93A violation. I don't see any such separate briefing, and I don't even know how you preserve the issue.
Yeah, no, Your Honor, I think that you're correct. Procedurally, I don't believe the issue was raised at the close of all evidence. There was some post-trial briefing on the issue of the 93A attorney's fees, but I'm not positive that the issue was preserved in motion practice about the sufficiency of the evidence or whether or not the court should have made the finding of the violation of 93A.
Did the court actually make a finding? Is there any place that we would look at in the record where the court found a 93A violation?
Other than in its judgment awarding double damages, the jury in its special interrogatories awarded $1,048 of damages for a violation of 93A. The court doubled that in its judgment and then made a separate award of attorney's fees. But I think beyond that, no, Your Honor.
Thank you.
So Your Honor, I'll touch quickly upon the issue of liability for 93A. The trial exhibit number 38 at volume 2, 106 is the electronic mail on which the 93A violation is largely predicated. It's an exchange that is, in my opinion, very benign. It is an exchange between the defendants and the auctioneer, basically saying this didn't work out. We decided to withdraw one property. We'd like to continue to go forward with you, perhaps on this or other properties. So please send me a new agreement, but we're done on this agreement. I don't believe it's the defendant's position. That was not enough for the trial judge to submit that to the jury, and a finding of a violation was erroneous. As to the attorney's fees, the law is very well established that there needs to be a causal nexus between the attorney's fees awarded and the 93A violation. And what the cases say is that's the legal fees required to plead and to prove a 93A violation. Those things are done very succinctly in this case. There's a single paragraph in the complaint at paragraph 13 alleging that this email exchange occurred and that there was what the plaintiff contends was an improper termination of the contract. And then there was this exhibit, trial exhibit 38, that was, I believe, probably submitted either without objection or as an agreed exhibit. I'm not positive. And that's the whole of the proof, if you will, on 93A. And it's
well, but it was a 5-day trial, right?
It was, but this isn't the scrambling of
Hold
the
on
egg.
for a second.
I'm sorry.
When the plaintiff submitted their request for fees, it was a total of $28,000. And I haven't had a chance to study this carefully, but it was a $28,000 all of the money they'd spent on a 5-day trial?
I don't
was
know
it
the answer.
itemized in some way as to things that had to do with 93A? Because then the judge cut that in half anyway, right?
I don't know the answer to your question, Your Honor, but I do remember seeing the exhibit and that there were some strike-throughs used for some of the time entries. So it could be that the 93A was not billed discreetly, but presented discreetly. And it just seems disproportionate. I see my time is up, but for $13,000 to plead a single paragraph and present a single trial argument in a 5-day trial that would have occurred in 5 days for the breach of contract with or without 93A. And we ask that the court reverse the judgment, Your Honor, and that's all. Thank you.
I see no further questions from the panel, so thank you very much for your argument. We'll turn now to Attorney Fallman.
Thank you, Your Honor. May it please the court, Edward Fallman on behalf of Jerome J. Manning Company. First, on the issue of waiver, I think it's fairly clear that the breach issue has been waived, and I don't even think they preserved it in the appellate brief. And in the JNOV motion, if you scrutinize the JNOV motion, it relates to the 93A damages, the 1,048. That's what's focused on by trial counsel. So that's really where the
Did they have to raise it on JNOV if they already had raised it as in their directed verdict at the close of the evidence?
They didn't raise it at the directed verdict. They didn't raise any issue of damage.
They raised the breach issue. They raised the breach issue at the end, at the close. They don't also have to make it in a JMAL motion, I don't believe, in order to preserve it for trial, do they?
Well, the way they briefed the appellate brief, they're challenging the denial of the JNOV motion, not the DV motion. So I think that was, defendants have put that, that's the issue they've briefed to the court, Your Honor, that the JNOV motion was wrongly denied. And that has to tie into the post-trial JNOV motion. So I don't think it's preserved. Now, certainly it's not briefed in their brief. So there's a second waiver at the appellate level. So, I mean, I think that issue is gone relative to this appeal. On the issue of the 93A conduct, I part company with my brother that somehow the short, plain statement of a complaint circumscribes the conduct that was presented to the jury on the 93A. It is not related to one email. And I brief in my brief, I set out a myriad of evidence that was put forth in the jury. Pages 38 and 42 of my brief is the record that establishes the 93A facts. I mean, this is a classic case where Mr. Ozdemir, the minute he was able to refinance his South Boston property, was looking for an out And an absolute auction agreement is exactly what you said. It is not cancelable.
Counsel, hold on, slow down for a moment. Looking for an out from a contract because you have a reason to look for an out from a contract is not a Chapter 93A violation, is it?
This is, but I went to go on, Your Honor. He was trying to leverage a better deal. If you see in the record.
How was he trying to leverage a better deal?
Because he wanted out of the absolute agreement, like you had pointed out.
I can't, that's a breach of contract. Simple breach of contract is not a Chapter 93A violation. Therefore, you got to give me something more than that.
Okay, well, if he says, I will give you back the property if you give me a better deal and go to the reserve auction, that is trying to leverage a better deal. And he can't get out of the contract. That contract is still in place. He can't say, the contract is terminated, I'm walking away, there's no more deal.
But that's all you're telling me about, counsel, is a termination of a contract. You're not telling me about something more than that. Now, the leveraging, he said, if you'll let me out of the contract, I might give you other business.
He didn't say
that's a 93A violation.
He didn't say, I'll let you out of the contract. He said the contract is terminated. Then they tried to use, because they couldn't get out of the absolute auction agreement, they requested a return of the advertising costs, which my client in good faith returned. His attorney then wrote a letter, your return of the advertising deposit is a termination. They could not terminate an absolute agreement. So they tried to, they tricked my client, Mr. Manning, into giving the money back. They said, oh, you returned the advertising cost, you terminated the agreement. That is 93A. That is unfair and deceptive practice, where they try to.
What way? Because counsel misrepresented the effect of your client agreeing to give back the $5,000?
No, that they underhandedly try to trigger a breach by my client to convince there was a termination when there was no such right to do that as the basis for we're canceling the agreement because you returned the
Their lawyer took a position which you say was so unreasonable it was a violation of 93A.
Absolutely. Not only that, he continued to postpone the agreement, saying, I don't want you to schedule the auction in Natick because I have to be in Turkey. When he signed a power of attorney, he's trying to unfairly delay it, not get my client to schedule it. He's then saying, well, I didn't tell you about the order of conditions and the fines because I didn't think it was relevant. This guy, Mr. Ozdemir, owns about 15 to 25 properties. He was obviously looking for an escape hatch by not disclosing those material facts.
Isn't that more of the same?
No, those are material facts.
Let me finish. Isn't that just him breaching the contract? What is the consequence to your client of the misrepresentations, which were all leading in the same direction, a breach of contract, which he ultimately did and was found to have breached?
He was trying to he was trying to delay this and not get the auction scheduled for the purpose of walking away so he could get a better deal when he no longer needed my client to auction the properties because he was able to refinance his South Boston. At that point,
it's not uncommon, and it has happened from the beginning of common law, that someone enters into a contract. They say, you know what? I don't like that contract anymore. I'm not going to follow it. I can get the goods over here cheaper. That's not a 93A violation. At least that's what our cases say.
Well, the cases also say, Judge, to breach a contract with the purpose of trying to leverage the other side. That's
Are you really talking about the covenant of unfair dealing? Are you basically saying that the contract was signed in the first place for unjust reasons? Is that your point?
No, I'm saying once he was able to refinance the South Boston property, he didn't need to sell these two properties quickly, which was the whole purpose of the auction agreement. You get a price and you have to close. He didn't need that once he refinanced. His financial situation changed. So at that point, he's looking to leverage Mr. Manning by unreasonably delaying it with phony excuses, by not disclosing material facts, which caused the delay, which then he wanted the advertising cost returned, which he then unfairly and falsely said, well, that was your termination.
Did you put in evidence that you can point me to that when the defendant instead of saying, hey, I'm done, I'm not going forward with this contract, said, I don't want to do it now, I'm not around. Do you have evidence that you put in the record that shows that you suffered additional damage as Mann and Company, that you continued to do work, that there was some kind of reliance because instead of telling you I'm done with the contract, they strung you out?
Yeah, so the damages on the 93A and the 1048, the jury did not award any duplicative damages. That's what the trial judge really focused on, the instructions, the Bright Builders case. They didn't want any duplicative damages. The jury came back with 1,048 damage award on the 93A, which directly ties in to what my client was out and the advertising costs out of pocket. The unfair and deceptive act was him, Mr. Ozdemir, falsely alleging, return the deposit, we're going to postpone, return the advertising costs.
Can you help me with the facts on that? So you got $5,000 prepaid for advertising costs. I assume the $1,000 was paid out of the $5,000 that you had.
No.
Did you return the entire $5,000?
Yes.
Oh.
That's in the record. The check is in the record, Judge. So
you sent them back the entire amount, even though you were out of pocket advertising dollars. Is that right?
Exactly. So that unfair and deceptive act, falsely saying we're just postponing, right? Give me the advertising.
Wasn't that advertising already expended before the stringing along that
it was not
now?
It was not.
Is that in the record?
Yes, Your Honor. So what happened at that point, the jury limited the award correctly because there was no duplicative damages tied directly into that unfair and deceptive act. That's where the damage arises from. So I think it naturally flows from that event, the unfairly requesting or deceptively requesting that all the advertising costs back on the allegation, we're just postponing, when Mr. Ozdemir had no intention of postponing. He wanted to cancel, and he couldn't because of the absolute auction agreement. That's the 93A violation that ties in to the award. Now, with regard to Mr.
Even if the $1,000 had been expended right off the top, it would have been expended before your client found out about the problems with each of the two properties.
Would it have been expended before? Would it have been expended before my client found out? Well, yeah, I don't know that. My client did the advertising on his website, on Facebook. I don't think he did templates to put the ads in. I don't think it got to that point. So I think that's true. I don't think he didn't put it in the paper yet, but there was advertising. So it wasn't incurred yet, except for the 10, he was out of pocket on the 10, 50, 48. So that's where the damage is.
What about on the attorney's fees? I'm sorry if,
All right.
Judge Vuono or Judge Sullivan, do you have a question?
No, go ahead.
On the attorney's fees, you asked for $28,000?
Roughly 29, yes.
And was that itemized in a way that showed that it was just for doing Chapter 93A, or was that all the expense of the entire trial?
The $29,000 incorporated not only the entire trial, it was up through the trial prep, etc. So it included the 5 days of trial as well as leading up to the time leading up to the trial. There was no allocation in the fee petition saying this part of the direct examination went to 93A, this went to the brief. The whole case was tried essentially as a 93A case. But because of the duplicative damages issue, the way the jury set it out in the special questions, they awarded certain under one contract, another contract, and then they came to the 1048. Arguably, they could have awarded differently and put the majority of the damages under the 93A count, I guess, if they wanted to. But nonetheless, I think they were very assiduous because of the judge's instructions on the duplicative damages. So
I don't think they could have. I think you have to tie it to causal relationship to the 90. Sorry.
I take it that your theory is that because it was a single chain of interrelated events that went to prove the contract theories as well as the 93A theories, that under the cases involving that kind of interweaving of facts, that you were entitled to the full award.
That is correct, Your Honor. I don't think it's a workable standard for a trial judge to, we have to excise in that point or itemize to that extent. And I don't think the defendant's argument that they have to be strictly apportioned. I don't think, again, that I think that they have to be apportioned. And I think Judge Rufo did that. If you read his order, when he gave a pretty hefty reduction, almost, more than a half of what the award was. So I think the judge at that stage was adjusting it and how he saw in his view of the trial, what he viewed as the proper 93A amounts versus what was allocated to.
I think
Well, you're
as I
not- excuse
understand the
me.
cases, sorry.
You're not saying that you're not required to proportion the attorney's fees and allocate them properly in your award, are you?
No, but I think on a
Your request for
five-day
an award.
trial, it's very difficult to segregate in a 5-day trial exactly what was apportioned to 93A versus what went to trying to breach a contract or the or the other counts of the complaint. I think that's tough to do on a 5-day trial.
Whether your theory at trial was, to quote Tennessee Williams, that there was a little bit of mendacity involved in this, and that your mendacity theory went to both the breach of contract and the 93A claim.
Yeah, it was a plenary approach, Judge. That is correct. I think that's how, I wasn't trial counsel, but it was a plenary approach as to how trial counsel did put the case in. I think it was all put in as one case with the evidence coming in on all the counts together. So I think when he did his fee award,
Would have been entitled to, I mean, there are certainly, look, as I understand the law, counsel, and this is just an observation, as I understand the law, if you want to get your 93A, you don't just throw the whole thing at the judge and ask him to figure it out. You have to tell the judge what he should allocate to 93A among what you did, and you have to explain why that is. And I'm not saying that you couldn't have said to him, look, basically every fact we put in evidence was part of our 93A claim, and therefore you should award everything that we did at trial. You would have trouble doing that here because there are certainly things that were dedicated to the breach of contract claim and to the breach of contract damages, which would not have been available in a 93A claim. But I don't think you can just sort of throw it at the court and ask the court to do the apportionment. I don't think the cases allow that.
no, I absolutely agree, Judge. It's not true. But I think what Judge Rufo did, based on the submission, I think in effect he did that. I don't think it was what he ended up awarding was clearly not abuse of discretion or clearly erroneous, which I don't think the defendants properly put the standard of review in their brief. That's a fairly high standard. So I don't think it arises to that level. Could it have been more artfully done or more succinctly done? Yes, that's no doubt about that. But I think at the end of the day, the way Judge Rufo handled it was appropriate. And I don't think it's certainly not an unfair windfall how he awarded the attorney's fees. I just he gave a significant discount on what was requested. So I think, as I said, in effect, he did that, even though I do agree that there should have been more segregation as to what was allocated to 93.
Okay.
And I see my time is up. If you have no more panels, no more questions, I'll just rest in my brief.
No, I'm checking with the panel now, and I see there are no more questions. So I thank you both very much for your argument. We'll take it under advisement. On behalf of the panel, we hope that you and your families stay safe and healthy during these challenging times, and we'll get a response to you as soon as we can. All right, I'm going to assume that, there we go. Screen says we're live. Good afternoon, and welcome everyone to the beginning of the court term this year. I'm joined today by Justice Mary Sullivan and Justice John Englander, and my name is Ariane Vuono. I'd like to take a moment to thank our court staff for doing such a great job of preparing all of us in this remote platform so that we can continue on and hear our cases in a safe and efficient manner. I'd like to thank all of you for participating virtually as well. During the course of the argument, it's possible that we will have a technological difficulty. We haven't yet so far today, but if we do, we ask you to be patient, and we can assure you that we will be patient with you if you have any problems as well. Just like to also say that the rules of appellate argument that apply to oral argument apply here just as they would if we were in the courtroom. So each side has 15 minutes. I know one side is splitting their time. There is no rebuttal. You can be assured that we've read everything that you have submitted to us, and we look forward to hearing your argument and your best argument is always wise to start with. So with all that said, I'm going to call the case officially for the record, which is 2019-1041, Sergio DESOUZA versus Childs Holdings and others. Childs Holdings, of course, is no longer part of the case, but that's how the case was filed initially. Okay, so Attorney Beatrice.
Thank you, Your Honor. Excuse me. May it please the court. I represent Sergio DESOUZA, owns and occupies as his residence a three-family in Salem, Massachusetts. Back in late 2008, 2009, he had run into some financial difficulties and was subject to foreclosure proceedings by IndyMac Mortgage Services. He initiated Mr. DESOUZA a HAMP inquiry to modify his mortgage, keep his home, and that occurred from the fall of 2008 and culminated in an agreement on June 22nd of 2009, and that's at appendix page 272.
I'm going to move you forward a little bit, if I may. Can you hear me? Can you hear me?
Yes.
Okay, good. If you don't mind, I'm just going to move you a little bit forward because we are familiar with the record and the background in the case. So this is an appeal. This is an appeal from summary judgment in favor of the defendant.
Yes.
And can you start by identifying for me point out to me where you say that there are genuine issues of material fact that would therefore require us to reverse summary judgment?
Okay, Judge. The court decision in this case was permeated with the factual finding that Mr. DESOUZA did not submit documents timely as he was required to do under the HAMP agreement. We contested that fact, and we contested it by affidavit, and it's actually contested by IndyMac's own employees' affidavit.
Is that really a material fact, given the fact that in the end, your client didn't qualify for the modification loan?
I think it's very material, Judge, and I also think that if you look at what happened factually at the very end, that the denial of his HAMP agreement, final modification agreement, was only made to cover up basically the negligence of what IndyMac had done for the previous 3 months. It's our position that they basically lost his documents after July 10th. And then they canceled the agreement.
Can we just stop there for a moment? I'm just going to follow up on what Judge Vuono was asking you.
Sure.
I take it then that your position is that he presented his tax returns prior to July 2nd?
Absolutely.
How do we know that? How do we know that? Where is that in the record? Because the judge said wasn't presented till late September.
It's in the record, Judge, in 2 places. One, the affidavit of John Beatrice, the attorney that was handling the negotiations, and that would be at page 106 of the appendix. I can just double check that.
What did John Beatrice say with respect to whether tax returns were provided?
He made the statement that all financial documentation requested was provided.
Well,
and
were the documents themselves provided then?
Yes, all the documents that were
No,
necessary.
I mean, wait a second. You have an affidavit from a lawyer that says all the documents requested were provided. Is there anything that indicates that he had personal knowledge of that, or that shows that those documents were in fact, and I'm talking now about tax returns, provided prior to late September?
Yes, Judge, 2 things. One is he states in his affidavit that it was corroborated that he was approved and that they will send recording for the loan modification, because that's their procedure. I don't want to digress too much, Judge, but under the HAMP guidelines, once the underwriting approves you and you're evaluated and you're approved, they send you the trial agreement, the TTP. And then
Not my understanding from the actual physical documents, counsel. My understanding from the physical documents is that the trial approval is conditional, and it's conditional on the presentation of additional documentation that will then be analyzed to determine whether he has sufficient income. You seem to be saying we provided that information. They concluded he had sufficient income. The judge in his summary judgment order said the opposite. If the judge is wrong, you need to point to the documents in the record that show that the judge was wrong.
Understood, Judge. I appreciate that. And I guess where we're having some difficulty in is procedurally what actually was supposed to happen. And that is on page 486 of one of the advisories that says that once you apply and then they evaluate you, and then they, and I'm talking about documentation, then they send it back to you once you approve, and then you sign it and send it back to them, and then they sign it and send you a copy signed. So
I'm not sure what you're talking about. Are you referring to the temporary initial approval?
yes, that ends up being a modification agreement once all the documents are signed and once all the payments.
Well, no, not exactly. The temporary agreement had more than one condition, and it had a number of conditions, correct? In other words, I think what you're saying is that your position is that the temporary agreement that was initially entered into would automatically become a final agreement. But that's not the case, is it?
It is the case once the payments are made.
Well, you have to make 3 payments for once each month, correct?
Correct, but once. And
submit the appropriate documentation. If it's in the affidavit that starts at page 103 of the joint appendix, I'm afraid that I can see it. That the appropriate documentation was in fact provided on a certain day. Judge says that it was not, and then in any event, your client didn't qualify for the final permanent loan modification in any event.
Judge, may I just point out the affidavit of any max employee at page 596?
Sure.
Talking about the affidavit of Erica Johnson Beck?
Yes, yes.
Right, she uses the word complete as having been received on July 2nd. And then when it was responded, look, you admit that it was complete, they submitted the affidavit of John Dickerson that says you are required to send income documentation such as most recent filed federal tax return with all schedules. My review of the business record shows that any MAC had still not received the required income documentation as of August 25th. And there's no response to that.
We were not notified of that as of that date. First of all, this affidavit states that the completed financial information was provided by July 2nd. And then it says,
doesn't tell us what the completed financial information was.
I understand that.
Just uses the word complete.
I understand that.
And you think that that's enough to establish an issue of fact without actually putting in the record from someone on your side, I submitted the financial information, including the tax return.
Given the
That's your position.
That, yes, given the additional facts that they sent the agreement back in late July, and then the notice, that August 25th notice, came 4 days after there was a notice that the agreement was canceled, which was only 10 days after the foreclosure was canceled. So the foreclosure was canceled August 10th because the financial documentation was provided. Yet they canceled the agreement just a few days later. And then there was a notification that we need more financial documents that we maintain were originally provided back in July. And that's in the documentation as well, Judge. That all that documentation
That's what I was getting at earlier, counsel, and I have to say I haven't received a satisfactory answer yet. You say we maintain the financial information was provided back in July. Where in the record can I find the evidence that the financial information was provided back in July, and what actual financial information was provided? Is the only place I should look the affidavit of John Beatrice?
And the documents that were resubmitted in September that were basically duplicates of what had already been provided.
Where does it say that the ones that were submitted in September were duplicate?
Let me just see. It's on page 107 on the appendix under the 9/14/09 entry.
So let me ask you another question, unless I don't want to tread on Judge Vuono.
Go ahead.
I'm going to go to a different issue.
Sure.
The defendants say once the income documentation was submitted in late September, he didn't qualify. In fact, he was 50% below what he needed in terms of income. I don't see any place in your papers where you can test that. Do you contest that?
Yes.
And why? What's the basis for contesting that? I don't see it in your brief.
The financial documentation that was filed with the two leases and his profit and loss indicated that he was making in excess of $5,500 a month, which translates into approximately about $1,720 that he could afford. And these are approximate numbers. And under the HAMP guidelines, the lender can adjust the monthly payment according to that 0.31 evaluation that he needs to meet. And they can waive interest. They can put it at the back of the loan to keep him at the 1,720 or 1,730.
Okay, so
but the documentation is in the bank statements, in the lease, and his P&L that were originally
information that the defendants submitted in their brief said that your client's income was $3,400 a month, roughly, and that the best they could do was get it down to $2,400 or something like that. So let me just finish. Are you telling me that if I go into the record, I will find that his tax returns indicate that he was at $63,000 a year income?
No, Judge, because he filed his 2008 tax returns. That's what they wanted to see. And the income was low because he was working in the real estate industry that had basically taken a nosedive at that point in time. So they asked for the P&L, and his P&L showed a net of $29.45 a month, plus the $2,600 in rent, which takes him to $55.54, which would qualify him for the max at $1,721. And I view that as a question of fact, is awesome. And they had this information, again, all summer, basically. And not to mention that my client's attorney was told 4 times in September that there was no foreclosure schedule. He actually had, because of his frustration and cancellation of the agreement in August, he asked the representative from Indy Mac to call Harmon Law offices and confirm that there was no foreclosure. This was on September 28th, which she did and confirmed.
I'm going to have to ask you to sum up. Your time has already expired.
Okay, Judge, thank you
I
very
don't know
much.
if you can. I don't know if you can sit there in the corner, but it's hard to follow in this format. But your time has expired just about 45 seconds ago, and I gave you a little time to finish up.
Okay, thank you, Judge.
All right.
All in all,
Any questions from the panel for Attorney Beatrice? All right, then we'll turn now to Attorney Fumarola, correct?
thank you, Judge.
Right.
That's correct. Thank you. May it please the court, I'm Carl Fumarola on behalf of One West Bank and IndyMac Financial. What the court was getting at in its question was cutting right to the heart of the issue. So I'll just jump right to that and address some of those issues. And the court's correct in asking those questions about point to the facts in the record showing that you provided all the required documents, and they can't point to any.
Well, what does Erica Johnson Beck or Sec mean when she says on paragraph 22, on July 2nd, IndyMac Bank finally received the completed financial information from Mr. DeSouza? And then
right, I think what she's making there, it's not artfully worded, I'll agree to that she received the packet. She received the packet that was completed, but then if you look several paragraphs later, she explains that it was missing the attachments. So they received the completed packet.
Where did she say that? Hold on. I read the several paragraphs later. I read your brief on this, and I couldn't find it.
Okay, I believe it is paragraph 34. She goes on to explain that how she told her attorney John Beatrice that it was missing the profit and loss statement and the proof of income. That's paragraph 34.
Actually, she says something different. She says that the original HAMP trial period repayment plan had been denied due to a profit and loss statement and proof of income information not being updated.
Okay, well, paragraph 32 is what I'm thinking of. Had not received current proof of income. So I think that it's clear, and maybe there are some other paragraphs. I can look at my brief and see what I had an explanation about that.
Well, the affidavit of Dickerson says that you didn't have his financial records as of August 25th, including his income statement. I saw that.
Right. So I'm citing to the record appendix to paragraphs, 22, 32, and 34, right, where it makes clear that they were still missing some documents. Well, I don't think that there's any dispute. If you look at the faxes, what my client was waiting for is what they received on September 14th and 24th, sometime in mid to late September. And those fax cover letters are in the record appendix. They're at pages 515 and 513. And it says attached, here is the proof of loss. And then the other one has the tax returns. And those items were listed in the checklist with the packet that Mr. DeSouza received back in June or prior to when the deadline, when he received it. And he didn't submit the documents by the deadline. But even aside from that, and I'll agree there's some noise.
Let's go past the he didn't receive the documents and address the last issue that we were talking about with your brother. Your brother says, actually, it wasn't $3,400 a month or whatever you guys calculated. It was $5,500 a month, consisting of a combination of rent and income. And that and that HAMP would therefore have allowed a payment of $1,700 a month, 31%. And you guys miscalculated, or you didn't do what you should have done in denying the modification. What do you say to that?
I didn't see any such evidence submitted in the record below. I didn't see any counter calculations provided by Mr. DeSouza. I don't believe this issue was raised at summary judgment where he responded to our calculations and said, no, these are really the correct calculations. No affidavit
I'm going
on
to interrupt
that.
you just for a moment. Excuse me, Attorney Fumarola. I wanted to be sure that Justice Sullivan could hear us. We lost her temporarily. Were you able to stay with us, Judge Sullivan?
Yes. Fine.
Okay. All right, good, thank you. I'm sorry, please go ahead.
And so I don't know where, I mean, some of these numbers are the first time that I'm hearing them from Mr. Beatrice. And I don't know if he's accounting for what my client has in his affidavit, that they can only count 75% of the monthly rental income. That's a standard factor across the industry because they assume perhaps maintenance costs or missing rent payments. So they can't calculate, they have to have a discount on that. So I'm not sure if he accounts for that, but the only evidence that was submitted and briefed below before the trial court, it was the calculations of my client, and that's that Mr. DeSouza did not qualify.
Let me ask a different question, which is, let's assume that in fact, Mr. Beatrice is right, and that, you know, 1,700 was the right number. Is there any law on whether your client then would have been obliged to enter into a modification? I mean, how do we address the question? Your client is saying, I can only get down to 2,400 or whatever the number is that was. Beatrice says, Mr. Beatrice says, 1,700 was doable. Is there any law that tells us how to resolve that?
Well, there is. There's some case law on that, and we have it in our brief where there's generally no duty to provide a loan modification. You have your loan, that your mortgage, and that's the obligation. There's no obligation to modify that. Now, there are programs where with the federal government where lenders agree to participate in a loan modification program, and this court and many other courts have held that that does not create a separate duty to modify a loan with borrowers. The borrowers are not an intended third-party beneficiary.
The HAMP program, which I understand you have to sign on to in some way, and someone comes along and shows, look, I can't make the payments that you have there, but boy, I have an income stream from which I could make payments. You know, if you go to 40 years and you forgive 10%, I have enough. You have no obligation to enter into that modified agreement. Is that the law?
That's correct.
And that's briefed in your brief?
Yes. Yep. Those don't have it right in front of me. We do address that on breach of a duty arguments related to those negligence claims and breach of contract claims. And so the issues that we just discussed, it's really dispositive of all of his claims. The fact that Mr. DeSouza did not provide the necessary documents by the deadline shows that my client was able to terminate the agreement, did not breach any kind of a duty or breach any kind of contract. And then also there are no damages because even if my client did not terminate the temporary agreement, he never would have qualified for a modification in the first place. And then also it's detailed in my
It's one of those reasons, I might just go back, it's one of those reasons is because the property had been transferred to a trust.
That's another argument, yes. And Mr. DeSouza needed a signed affidavit.
How significant is that really?
I don't think we need to rely upon it, but it is certainly a basis for that allowed my client to terminate the agreement. It didn't know it at the time, but if they had known, and if Mr. DeSouza did not sign the affidavit indicating he still owned the home, if he didn't sign that, falsely,
why do we care?
My client never would have granted the modification.
Nominee trust, right? What I think maybe Judge Vuono is asking the same question I had on my mind.
Yeah.
Is there any legal significance to the fact that he owned the home as in a nominee trust rather than in his own name?
I think it was required because for just standing to sign the contract documents, if Mr. DeSouza is signing the documents in his individual capacity and not as a trustee, then the contract's not effective. That's probably the main factor.
But I thought what you were, well, okay.
Right, unclean hands is an argument. There are numerous, their claims failed for many reasons.
Didn't even know or think of the fact that he had it in a nominee trust rather than his own name, because as I understand the law in this Commonwealth, there's essentially no difference.
Right, he swore under penalties of perjury that the house was still in his name and it wasn't. Maybe if he disclosed those facts, then it would have been different. And they probably would have worded the contracts differently.
All right, you have about 25 seconds to sum up.
Based on the factors that my client was able to terminate the agreement and he didn't qualify anyway, there's no breach of no duty for his contract claims, his negligence claims. There's no damages, which is dispositive of all of his claims, including the 93A claims. There is no reasonable reliance on the issues of some of the mistaken statements and actual knowledge.
I'm sorry, I have one more question. I'm interrupting, I know.
Sure, go ahead.
But is he still in the property?
He is still in the property. That's why this case doesn't make sense from a practical standpoint.
Payments in the last 11 years?
My client, the loan was since transferred to another servicer. And there's been a loan modification. That's a public record in the Registry of Deeds, and he's still in the home. So there's no harm for this case.
Okay, thank you very much, Attorney Fumarolo. We appreciate your argument. And now we'll turn to Attorney O'Leary.
May it please the court, my name is Edward O'Leary and I represent Harmon Law Offices in this matter. As the court knows, One West retained Harmon Law Offices to conduct a foreclosure sale on its behalf of his property. That was the scope of the engagement, and that is the representation that Harmon Law Offices provided. And that was, so One West was the client, not the plaintiff, and Harmon Law Offices completed that foreclosure sale on September 30th, 2009. Now, shortly after one day after the foreclosure sale, the plaintiff instituted the action in Superior Court, filed there were 7 claims in which he made allegations directly against Harmon Law Offices. And the court, the trial court, awarded Harmon Law Offices summary judgment on all 7 correctly on all 7 of those claims. And the first reason, I think, and probably the most important one to go to first, is the applicability of the Galliestro case. In Galliestro, that's an appeals court case. The plaintiff in that borrower alleged fraud.
I have to interrupt because I have an issue that just arose from the answer that Mr. Fumarolo gave, and it goes to whether at least aspects of this case would be moot. Am I being told that in fact there's been a loan modification and that the plaintiff and his successor mortgage holder have entered into some kind of agreement?
That was my understanding from what Attorney Fumarolo told the court, Your Honor.
So
that's my understanding, Your Honor. I'm sure that Mr. Beatrice could answer that question.
That's correct, Judge, if I may.
So one of the things that you were looking for in this case was to unwind the foreclosure. And that apparently is moot. Am I right?
That would be moot with the issue of title to the property, but not the issue as to damages, because they did conduct an illegal foreclosure and my client has suffered harm because of it.
Justice Vuono, it might be useful to have a 2-page document that explains that so that we understand the full factual context.
So Attorney Beatrice will ask you to submit a 16L letter setting forth those that information. And of course, if either Attorney O'Leary or Attorney Fumarolo want to respond to that, you'll be able to do so. Okay, can we ask you to do that within a week or so?
Absolutely, Judge.
I think it's just the facts, at least from my perspective. No, just the facts that go to whether or not aspects of this case have been mooted.
And Your Honors, whether the foreclosure was lawfully conducted, that's really a matter that's sort of beside the point for Harmon's purposes. It conducted a lawful foreclosure, and that was what it was hired to do. The Galliestro case, if you look, the plaintiff in that matter alleged fraud, civil conspiracy, and violation of the Massachusetts Consumer Protection Act. Same 3 claims that have been presented in this, and the court correctly entered summary judgment for Harmon in that matter. The trial court went on to hold here that the negligence claim and gross negligence claim there was no basis against either defendant because, well, particularly against Harmon because it owed no duty to Mr. DeSouza. Harmon's duties were owed to its client. Mr. DeSouza was, and the Griffo Trust was their adversaries in this matter, and Harmon owed no duty. Similarly, the summary judgment entered on behalf of Harmon on the promissory estoppel claim because the plaintiff didn't point to any representations that were made by Harmon as opposed to the lender. And that's, you have to have a material representation that's reasonably relied upon. And as the trial court pointed out here, there was no representation made by Harmon and certainly nothing that Mr. DeSouza could reasonably rely upon. And as to the breach of contract claim, Harmon is outside counsel for the lender. There's no contract. To have a breach of contract claim, you have to have a contract. There's no contract, and none was pointed to, either verbal or written, between Mr. DeSouza and Harmon. In the absence of a contract, that breach of contract claim must fail. And then the fraud, misrepresentation, and civil conspiracy claims, those were all correctly, summary judgment was correctly entered on behalf of Harmon because there are no material issues of fact in the record before the trial court that would support any such claims. The Galliestro case is on point. It's not perhaps with regard to the fraud claim because that was deemed waived in Galliestro, but definitely with regard to the misrepresentation and civil conspiracy claims.
Right. So your time is up. It may be hard to notice that when you don't have the light flashing in front of you. I understand that. But I think you were really summing up at the time I interrupted you anyway. But fair is fair. Your time is up. Did anyone, Justice England or Justice Sullivan, have anything else they wanted to ask Attorney O'Leary before we close the argument? Looks like no. Okay. All right. So thank you all very much for your argument. We're going to expect a 16L letter from Attorney Beatrice. I want to thank all of you for participating in today's argument. On behalf of the panel, we hope that all of you and your families stay safe and healthy during this difficult time. Once we receive the document from you, we'll take the case under advisement and again answer as soon as we possibly can. Okay.